Item 1 and 2 for admission.
None appears for the appellant adjourned. Next.
Item 3 for motion.
One 20, 15, 10, 15, 9.
Hey, please, the Lordship. Lordship, here in this case, petitioner said
Then
Lordship, here in this case, Lordship, petitioner was declared as a foreigner.
who is the father of the petitioner?
Lordship, petitioner's
Page number?
father's page 18 is
18.
1966 voter list.
Page
Ashraf
number
Ali.
18, just a minute. Page number 18, Ashraf Ali Sheikh. He is the
Yes.
father.
Yes, Lordship.
Very well.
And-
Now, which document or material will show he is the father?
Lordship, kindly come to page 47.
47.
Is a registered cell deed, Lordship.
Registered sale deed of which year?
In the petitioner's name, Lordship. Here is the petitioner's father's Lordship. He's the seller. Lordship, kindly Likitong. Next page, Lordship. Musammad Sajiron Bibi, Shami Soyangsu, and second seller, Musammad Basiron Bibi, Shami Muhammad Gulal Mia, Uboyer Pitha, Mito Asaraf Ali, Urofe.
Yes,
Hassan.
remember what you said? The two ladies sold some land,
Yes, Lord.
showing them to be the daughter of Ashraf Ali.
Yes.
But address is Bosar Kuri, same village.
Different address, yes, Lordship.
Timing, let us admit.
Lordship.
Timing, let us admit it.
Yes, just notice me.
Notice it.
Issue, Lordship.
Your name?
I have Lordship.
I hope. Petitioner relies upon the voters list of 1966 of village Bosar Kuti.
Pasu.
At page 18 of the petition. As well as a sale deed at page 47, by which Basiran Bibi, daughter of Ashraf Ali of Basar Kuti village, had sold a plot of land at village Basar Kuti.
Sale deed is executed in 2012.
12.
Sale deed is executed in, registered in 2012.
12.
12. That will be my.
Lordship, in the meantime,
Interim.
We don't want, no interim. Next item.
Lordship,
This is interim.
I leave less much.
Item 4.
If you don't want, you tell us. Yes, Mr.
Lordship, petitioner was declared foreigner, Lordship.
Item
Petitioner,
Item
item 4, Lordship.
4. Item 4. Yes.
Lordship,
You are I Hussein.
no, Lordship, I am appearing on behalf of I Hussein, Lordship. He is out of station,
Bihar.
Lordship.
If you
Is
sign the wakalatnama,
Is it permissible?
Lordship, it's so.
Don't know. You check up if it is permissible. We don't mind hearing you.
Actually, not permissible. If you Lordship allow, then
Sorry.
if your Lordship permit, otherwise.
No. Had Mr. Hussein remained present, and you are arguing the matter in presence of Mr. Hussein, it's okay. We accept it. It's not no difficulty. Although technically that also should not be accepted. But in the absence of anyone, suppose for some reason, today I dismiss your petition. What will happen? Tomorrow somebody will raise an objection that I Hussein is the counsel.
That is.
Who asked the court to hear somebody else and dismiss my petition?
Lordship, then another date may be.
If it is allowed, well and good, no difficulty. If it is in favor, suppose it is against, technically possible. You may dismiss a petition also, not that mandatorily it has to be admitted and this thing. You bring Mr. I Hussein with you or Mr.
Lordship,
Rahman will hear you.
Lordship, today not possible. They are out of session. And any other day.
We are ready to hear LR Mojumdar, but
Lordship,
must be accompanied with either Mr.
I
Hussain
have
or
understood,
Rahman.
Lordship, I have understood.
Okay.
Any day after.
I turn on the prayer, Mr. LR Mojumdar, Student Council appearing for the petitioner.
7th August. Item 5,
Yes, Mr. J. Abbas,
May I please, your Lordship?
who is the father?
66 Lordship.
Page
Yes,
number?
52 Lordship.
52.
52 Lordship.
Name?
Name is Lordship, Bengu Sheikh. The serial
Bengu is
number-
the father.
He is the father Lordship.
Village is
Village-
Deotari.
Devtari.
And now which material will show Bengu is the father?
One Panchayat certificate was issued by the Panchayat Secretary. Lordship, after taking statement of two witness, Lordship, that is at page 64, Lordship.
After taking statement of witness. Who is the witness?
Witness from villagers. And Lordship,
Witness from village, what does he say? The secretary is competent to give the certificate.
no, that not
Yeah.
that, Lordship. They said that I know them, I know him, they are regarding their ancestry. They have that statement. He has
So
the
you are relying on the certificate or relying on the witness?
on the certificate, Lordship.
Certificate. Petitioner relies upon a certificate issued by the Panchayat Secretary to substantiate that Bengu Sheikh is the father of the petitioner. Establishment of a relationship is covered by section 50 of the Evidence Act. Petitioner to examine as to whether the certificate of the Panchayat Secretary satisfies the requirement of section 50 of the Evidence Act. Just again, next slide.
Lordship, protection. Maybe.
First you satisfy that, make out a prima facie case, will give you all the protection.
He has a.
When do you want? Take
Exam
the
mind,
date.
Lordship.
Next item.
item 6,
Page 66 is the
66 is the
Item 6 was here, no?
page number.
66 is the impugned order. ma'am.
Forget about the order. Where is the name of the father?
Name of the
6.
father.
Page number.
Item 6. Yes. What the-
This is item number 6, read petition 4151, Nazma Begum.
I'm sorry, my lord.
Yes.
My lord, please, your lordship, my lord. There, my lord, petitioner had filed, my lord, written
Mhm.
statement, my lord, but could not file the evidence. My lord, he is in.
Pay a cost of 5,000, go back.
My lord,
Pay a cost of 5,000, go back.
my lord, she is. in
Don't want to pay.
No.
She's in detention,
Detention,
Lordship.
that is right. He may be released now.
She will be
Okay,
released.
release and go and appear.
My lord,
Yes, and
Release with all those biometrics, etc. That
my lord.
Lordship, even the fine, because she did not appear after the notice was served, Lordship.
so you pay a cost.
Fine.
Heard Mr. S. Hockler and counsel for the petitioner also. The petitioner MUSTT Nazma Begum was referred to the foreigners tribunal number. Where is
Jorhat, my lord.
Jorhat, Lordship.
Jorhat? For rendering opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of case number FT/CRD/2/2018, page 36. The tribunal rendered an opinion dated 14/12/2018 declaring the petitioner to be a foreigner. It is noticed that the petitioner, even after receipt of notice from the tribunal, did appear, submitted a written statement, but thereafter did not appear in the tribunal any further, and no evidence or any material has been produced to discharge the burden under section 9 of the Foreigners Act 1946. From the facts and circumstances as noticed from the records, we do not notice any infirmity in the order dated 14/12/2018. But however, for the interest of justice, the petitioner is given another opportunity to discharge the burden under section 9 on merit before the tribunal. But however, for the conduct of the petitioner in not appearing the petition tribunal without any reasonable cause, the petitioner to pay a cost of ₹5,000 to be deposited before the High Court. Full stop.
Oh, yeah.
It is stated that the petitioner in the meantime has been taken into detention.
Right.
The petitioner be released from detention.
On a bail.
Condition can it be on the condition of
Biometric.
interim order or Jikita condition. put in all those things, IDs and biometrics and those things. It's okay, Madam Verma?
Yes,
Those
Lordship.
interim order conditions will be imposed
Same
while releasing,
conditions, biometrics.
and the petitioner to appear before the tribunal on so and so.
Lordship will fix a date and some stricture, Lordship, that two
It
thousand.
is expected that the petitioner would cooperate with the tribunal in the proceeding. Any further deliberate non-appearance would be viewed strictly.
Lordship,
SP border.
there are
Sorry,
SP border Soraido as well as SP border Jorhat.
Read that video, satisfaction of
The competent authority will release,
Okay.
Lordship.
at a fixed date on that day. It is expected that the petitioner would be released from custody before the next date fixed.
21st August. Item 7.
This item 7,
Page 66, my lord. improved order.
66.
This one, Nikhil? Okay, this is not it.
Why are you referring to page 66?
Page 66, the impugned order, my lord. Impugned opinion.
So the petitioner refers to the impugned order
No, Lordship.
and they relies upon the impugned order. If the impugned order is correct, no further requirement of writ petition closed. Next item.
My lord, and my lord, I'm submitting, my lord, my page 17 is the annexure 1 is the NRC details, my lord. My father's name is mentioned there.
Mr. Counsel, we are asking you to discharge your burden. If you are referring to the impugned order and relying on that, if that is correct, we
I'm just showing, my lord.
you don't have to show. We are wasting time by showing unnecessary things. Who is your father? Please tell us.
My father, page 17, my lord.
Page 17.
Yes, my lord. Abdul Ghani is my father, my lord. Page 19 also NRC details.
NRC is not admissible in evidence. Any other material?
66 voters, yes.
My 66 voter list, my lord, kindly see.
Mr. Counsel, you take the advice from Madam Verma, get prepared, come back, we'll hear you. Yes, next item.
Time being, Lordship.
We want only two materials. Document material showing the name of the father, other material showing that this person is the son or daughter of that man. You don't need anything beyond that.
I have this, my lord.
If you have, you ought to have shown. Twice we are given the chance. Next item.
66 or
After some
70.
Item 8 for admission.
Please take note, prepare, come back. We'll hear you. Yes, item 8. Minoti Roy, that matter.
Yes,
What
sir.
happened?
Mr. Dinat is supposed to be present today, Lordship.
Hmm.
Mr. Dinat. I have received the instruction, status super, Lordship.
Personal lordship direction, my lord.
Where is Mr. Nath?
He is supposed to come, Lordship.
We'll take up in his presence.
Lordship.
We feel that there may be a requirement of a judicial order because the police is not cooperating in telling the correct facts.
Lordship. After some time, Lordship.
Item 9.
May I please, your Lordship?
Yes.
Lordship, in this case, the last order was the Home Department to produce original Jamabandi.
Lordship will have to give me some.
Original Jamabandi. Who will bring it?
Is it asked Home Department?
Home Department, yeah, last.
So last date, Mr. Paying said we'll bring it.
He will bring up upon.
Lordship will, for the timing, Mr. Pine may be around, Lordship. I'll ask him to come.
First order was Revenue Department to produce. Revenue Department is could not produce.
Hmm.
Then on 22/6, Mr. Paying Home Department states that the Home Department itself would bring the record.
Lordship will give me some time. I'll just ask Mr. Pine to come. call up Mr. Pai, you know his number? Which order was that? Which date the order was? Just give me the date.
Wood itself overlap, wood itself being the overlap, wood itself is 6.
22.
But take line by line, what does it sound like? Next.
Item 10,
Halima Khatun, yes.
No, please, Allah. Father of the petitioner is Hanif Ali Mullah.
Page number.
Page number.
So daughter is Halima, father is Halim.
Hanif. Lordship, notice has already been issued.
Uh,
on this matter.
the voters list,
No,
page-
record that here.
Records are there, Lordship.
yes, 115 lordship, 115.
It will give a home department of Jamabandi by the annual decision. Last order.
Hanif Mullah,
Hanif Mullah is the father.
father lordship, and this one is uncle,
Who is uncle?
Atabar Mullah
Atabar, Atabar is the uncle.
Gaumbura. Elder brother of
Gosai,
Gosai is the grandfather.
grandfather, very well. Now, which material show Hanif Mullah is the father of Halima?
Lordship Gaumbura certificate,
Page number.
page 139 lordship. And even the Gaumbura, who is also the cousin of the petitioner,
He's a dangerous Gangura.
because his father Atabar
Right.
was also the Gaumbura,
So
and his
that's why I said he's a dangerous Gangura. His Gangura also a cousin.
her brother also has adduced evidence as DW4,
Page number 139 is the Gangura.
Gaumbura certificate.
So Gangura is also a cousin.
Yes, lordship.
Where is the evidence of the Gangura?
Evidence of Gaumbura is at page 92, lordship.
Page 92.
Yes, lordship. And even her own brother also has adduced evidence,
Understand?
whose name appeared along with the father.
One by one.
Yes, lordship.
Abul Mullah,
Yes, lordship.
50 years.
Yes, lordship.
What is the age of the petitioner?
Petitioner age at present is 41.
41.
You said the grandfather was this one, Akbar Mullah. This one. This uncle, and this is the father, Hanif Mullah.
Yes, Madam Burma, this is a good evidence.
Lordship,
This evidence at page 92,
yes.
it appears to be good evidence. It does satisfy section 50 evidence act. Only aspect is most of these informations are also available in the voters list and other related documents.
Voters list of 70 has the father's name, again 77. It's a single voters list. The uncles and all are
These
missing. Lordship.
are not very relevant.
Lordship may
Single
remand
voters
it back
list
then.
because when they apply, they are given one name. That doesn't mean that voters list doesn't contain anybody else's name.
I didn't, in
Hmm.
other cases, Lordship is asking for the complete voters list. That is the reason I pointed that out,
Understand,
Lordship.
but if 70 is good enough.
In
why-
85
And again, 85 from 77 to
But
85.
look at the evidence at page 92. Is very specific from para 4 onwards.
Lordship may send it back to the tribunal to reappreciate, Lordship.
And in the tribunal, you also produce your Aadhaar card that you are actually Abul Mullah, son of Atwar Mullah.
Because she does not have a voters list with her
Because
own
the
parents.
only link is the evidence of Abul Mullah.
And also DW4.
Who is he? Page number?
DW4 is her own younger brother,
Page number.
Ashraf Ali, 99 Lordship.
Lordship,
And father and the younger brother, DW4 is together, there is Lordship.
that is in
in-
2005, Lordship. If the one brother's name is there, what about the other siblings? Why their names
Then
do
you
not
have
figure
to
with
meet
the
her
parents?
objection, produce the complete voters list of what.
If there are
It is
4 or
there,
5 of them,
85.
Lordship,
2005 also, normal list
No,
also
no.
is there.
From 70 onwards,
Yes, sir.
continuous complete voters. list.
Yes,
That's
that
what
we
she's-
will submit before the learned tribunal. If it's order reflected in the order.
yes,
we will
Lordship, let her submit and let, if there are
So
other siblings, their
now-
names should also figure, Lordship.
Ashraf, who is Ashraf?
She said
Younger
the brother.
brother.
That means there must be an elder brother or a sister also, then what
Sister
about them?
name may not be there because usually they get married prior to their age of adult franchise.
Even if they get married, they must be having siblings, yeah.
Not in the same village, it will be in the other
No,
village.
I mean the family has a.
Family list
That's-
is there,
that is what I'm saying.
2005 list is there.
Yes. Heard them as the host and counsel for the petitioner also. A. Verma. The petitioner Halima Khatun was referred to the foreigners tribunal
Number 2, Kamrup Rural,
number 2 Kamrup Rural for rendering an opinion as to
page
whether
47 is that. order.
whether she is a foreigner under the Foreigners Act 1946 being agreed, the state petition is instituted. The resulting registration of case number BFT, case number 1318/2016. The tribunal rendered an opinion dated 10/10/2019 declaring the petitioner to be a foreigner being aggrieved. The state petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of which page it was 113.
Yes, Lordship.
I think
And there are 6
113.
siblings, Lordship. Any voters list to show the names of
I
the
will
siblings. will be-
direct them to produce the complete voters list.
Yes.
It's there.
Where is that voters list gone?
With the brother and father.
No,
together.
father.
The
Father is
77,
115.
150.
Relies on the voters list of 1970 of village
Chaudhary.
Chodhuripara, Moza Hontoli in the Borpeta district,
No,
which contains the name of no, in the Kamrup district, which contains the name of Hanif Mullah, son of Gosai. At serial 180, it is claimed that Hanif Mullah is the father of the petitioner. To substantiate that Hanif Mullah of the 1970 voters list is the father of the petitioner, reliance is placed on the evidence rendered by Abul Mullah, son of Atwar Mullah, who Atwar Mullah, who claims to be, who had stated in paragraph 4 of the evidence in on affidavit that Abbas Ali is the great grandfather having 4 sons, namely Gosai Mullah, Soban Mullah, Sokman Mullah, and Kolimuddin. Gosai Mullah, who is also known as Haji Gosai Mullah, had 2 wives, namely Matabon Nessa and Mofidul Bibi. And Matabon Nessa had 8 children, namely Atawar Mullah, Somed Mullah, Asad Mullah, Hanif, and Hanif Mullah. Hanif Mullah, Gul Meher, Kul Meher, Suk Meher, and Mul Meher. Abul Mullah claims to be the son of Atwar Mullah, whereas the petitioner Halima Khatun is the daughter of Hanif Mullah. And therefore, Abul Hussein claims that he has the special means of knowledge to discharge the burden under Section 50 of the Evidence Act to establish that Halima Khatun is the daughter of Hanif Ali Mullah. Evidence rendered by Ashraf Ali is, as DW4 is also relied upon, where Ashraf Ali is the son of whose son? Is the son of Hanif Mullah,
Alipullah.
who also deposes that Haliman Nessa is the daughter of Hanif Mullah. In view of MS A. Verma and Council of Home Department raises an objection that although the name of Ashraf Mullah and Hanif Mullah appears together in the voters list of 2005 of village Choduripara, but the in-between voters list are incomplete. Full stop. In view of the above, remanded back to the tribunal to examine the voters list of 1970 of village Choduripara, as well as all the subsequent complete voters list of village Choduripara up to the year 2005, to cross-check the evidence rendered by DW3 and DW4 regarding the family tree of the petitioner. DW2 and 3 to also produce their Aadhaar card in original before the tribunal to establish that the person concerned is in fact the 2 persons who are claimed to be to establish that the person appearing before the tribunal is in fact the DW3 and 4 respectively. Upon doing the respondents may make their verification, submit report upon doing the needful written order.
The electro photo identity card, and he as a guard, that also was
Aadhaar.
exhibited.
Electoral card can be more easily obtained.
Yes.
Produce the Aadhaar card,
Yes,
show that I am this person.
yes, Lord.
Because
For DW3 and
because some
DW4.
cases
Yes, Lord.
we are having a feeling that it is somebody else who is projecting himself as that man. And mind you, most of this information given is also available on a thorough examination of the voters list. If you examine all the voters list,
Yes, Lordship.
anybody can come and depose this information.
Because the entire family, even the children's name,
Absolutely.
everything he has stated.
Everything. Very good.
Because,
So it is available everywhere.
yes. children. Review.
You produce the Aadhaar card.
Yes, Lordship, we will produce.
Item 11,
Lordship, item 19,
Verify no for it.
Lordship in item, it would be as one, 11.
No, this condition we are putting,
Yes, Lordship.
suppose Madam Verma goes to the tribunal, projects herself as Madam Ghosh and gives the evidence, what will happen? No one is verifying this aspect. So let there be a verification process also.
Lordship, they verify with the I-card, any identity card of that person, either the.
I-card is also available in the shop next to the High Court.
Electro photo ID.
You can go to that shop just below the masjid in that corner. Tell him, give me an iCard. It is available there also.
It's a government identity.
So government is also available. Don't worry.
It's a
So
government.
iCards have no value. Go for the original document Aadhaar card, because Aadhaar cards are issued after a lot of verification.
My lord,
Item 11.
Yes, the item 11,
your father's name,
page
line
number
33, my lord, 65 total.
33.
Abdul Khalid.
Abdul Khalek is the father. Very
My
well.
lord.
Now, where is Gerua?
My lord, page number 52.
Yeah, Gerua, good. Jamabandi.
My
Which
lord.
page?
52, my lord. 50, page number 53, my lord, Fatima Khatun, late Abdul Khalid. The petitioner name recorded in the next.
When did Abdul Khalek die?
10 years back, my lord. 10,
Then
11
why was the mutation made in 2020? Mr. Aman,
my lord.
till a few days back, we are taking these documents without any question. But after examining this Jamabandi for at least about 100 matters, we find that invariably the mutation orders are from 2018 or 2019. And here is a case of 2020. Why these mutations are not taking place at the appropriate time when the person dies? Why these mutations are always relied upon in the tribunal, and these mutation orders are passed only when you need it for the tribunal purpose? That means for the mutation purpose in general, you don't need these mutation orders. But when you are required to prove who is the father in the tribunal, you require a mutation order. So you are getting the mutations done. Why is this phenomena happening?
Because it's a family.
I am telling you, this is a question put after examining at least 100 Jamabandis.
Very well.
Initially, we never posed this question. Why we are not getting a single mutation order of 2005 or of 2010 when Khalek actually died? Sometimes it happens, the children are not together. Someone is in the USA, someone is elsewhere, somebody is that. The family needs some time to get together to apply for the mutation. In those cases also, the delays are of a few years here and there. But it's not specific to 2018 to 2020.
One reason could be, my lord, there could be some kind of problem in dividing the property. That could-
Nothing. How the problem suddenly eases out in 2018 when you required it to be produced before the tribunal?
Because of the urgency, probably.
I'm telling you, this is, so
But I
this
agree with the-
statistical information is compelling us to
My lord, I agree with you, lord.
raise this question.
They even referring to a sale date of 1950, lordship.
Page number?
Page 14, it's in one of the paragraphs, they're
No,
relying.
because Mr. Awan, you see, if you follow the recent history of these proceedings,
My lord.
at one point of time, the certificate of a Gaumbura and a secretary, yes, proved everything. When he started raising the question how the secretary or the Gaumbura knows about this fact, because at that stage, section 50 of the Evidence Act was not at all relied upon by anyone. And the relevant provision of law to establish a relationship is only section 50 of the Evidence Act. How to, in law, how to establish a relationship. So when we questioned that, the next set of documents happened to be by relying on a judgment on school certificate, get hold of a school certificate and the evidence of the headmaster. when a few unacceptable materials were brought to the notice of the court, we started calling for the
School register.
admission register of the school. And up till now, out of 10 or 11, I think 11th one also happened a few days back. Out of the 11 registered verified by the court, 10 were fraudulent and manipulated. So that means these litigants found out an easy answer. Let's go to any school, convince the school authorities to manipulate the school record, get a certificate, go to the tribunal. Now, when these are questioned, school certificate, now the next state of document that is coming is a mutation order. Till January, February, mutation orders were very uncommon to rely upon. But when the school documents are questioned, now the latest document in vogue is mutation order. You keep sitting in the court, out of 40 matters, you'll find almost 30 matters are relied upon on a mutation order. And mutation orders are everything of the year 2018, 19, and 20. Don't you notice a correlation of the entire aspect? Be fair.
Yes, sir.
Don't you notice?
Yes, sir.
See, when facts are sought to be created, in the first or second instance, you may go through because it's a new innovation of the entire thing. But when that innovated method is adopted repeatedly, something beyond is always discernible. But then why is it happening? Why not a single mutation could have taken place when the man had actually died? Why the mutations are taking place only when you urgently require it to be placed before the tribunal? And now another set of documents is coming, sale deed, purchaser. These litigants, instead of finding out all unscrupulous means here and there how to get over the system, why don't you understand Section 50 of the Evidence Act and discharge the burden? It's a very easy option for you, legitimate, accepted in law. Also, it will be acceptable in court.
Brother also deposed, my lord.
Understand? Show the brother's evidence.
My lord, page number 76.
See, now the stage has come, we'll have to slow down these proceedings.
Hello.
We'll deal with only 2 or 3 matters in the whole day. We'll be bound to examine each and every word. And it will you who will suffer. Because your cases will pile up.
Lordship, by the affidavit shown by the petitioner, she is 56 years. That means she is 66 born. If she is 66 born, her name ought to have been in some voters list after with her parents' lordship. And
No, their claim is these ladies, they get married before they attain the age of 18. So the occasion for having the voters list with the father does not arise at all.
that
think-
does not arise, but the mutation comes because what I'm trying to submit is at the fag and lordship will just see the way this matter has moved, lordship. 2001, the reference was initiated. 2011, she appeared in the court. And this opinion has been passed only in 2022.
Yeah, just
11
before
years,
the opinion,
Lordship.
go and get the hold of the
And
mediation or the
yes,
place.
and even now, Lordship, at the fag end also, with all documents which do not support her claim to be a citizen, Lordship.
And you are relying on some sale deed at page 44.
Lordship, that sale is previous
That
of
is-
1950. That
that
is
is the-
what is perturbing. If it is of 50, then the 66, that voters list and the 71 cannot connect to them, Lordship.
My lord, that-
66 is Abdul Khalek, age 38, Geruati.
A 66 voters list is, if the father is 38 years, the daughter must also have been born the same year. Because her affidavit one is 56 years.
my lord, this land has been sold off, this page number 43, my lord, that 1950 land, it has been sold off, my lord. Jamabandi does not come from this land, my lord,
Then why did you annex it?
because it was there in the, before the tribunal, my lord.
So before the.
Why did
tribunal-
you place it before the tribunal?
That I don't know, my lord. Probably just to show that he had a piece of
Existence.
land in 1950,
No.
my lord.
Showing a land document is showing the existence in India, Lordship.
My lord.
And 1950 document is just picked up and made a document. Maybe the land is also not
Let us
there.
see the origin of this page 44.
Page 44, my lord,
Let us take a look at the origin of this document.
the next page, my lord.
No, original. Lordship wants to see the original one.
Original, my lord.
Because the 1950 document will have a look of Mr. Nath, have some, you have some other matter.
At 11 court, one is sitting, one item is there. I'm just in 2, 3.
You want to come back. Otherwise, you did call up next item.
Correct. Lordship,
Okay, then you come back.
Item 1 is there. I'll just come.
My lord, this document was authenticated by the issuing authority, my lord, page number 81, my lord. I don't have the original one, but page number 81, my lord. '82 is the relevant portion, my lord.
Jaggaram Sharma.
Yeah.
Who is he?
This is the LDA,
LBA sub-registered Nagaon.
my lord.
Today I am present. I have brought the volume so and so as mentioned in the summary. Resident of Kholihamari. But Abdul Khalek is of Geruati.
My lord, he bought a land at this place, Kholihamari, my lord.
Why?
Currently, he was working there for a while. So he bought a piece of land and he sold it off, my lord.
No, he is a Abdul Khalek of Hang.
His village is Geruati, my lord. All voter list and subsequent documents are from Geruati,
That is your claim, Mr. Raman.
my lord.
But this sale deed, this Abdul Khalek is of a different place. Kholihamari or something.
My lord.
Whether the Abdul Khalek of
Huh.
65 and this one are the same or not, we do not even know that, Lordship.
That's a aspect.
But even if you do not take this document into account, from 1965, my lord, all
No,
documents are from
if you
Geruati.
don't take into account, the next question is that why did you place it before the tribunal? If you had placed a document which does not pertain to this man, that means there is a mens rea in this person to mislead the system.
The claim of the petitioner is that this document belongs to his father, her father. That's why it was
Whether,
submitted.
whether this Abdul
So
Khalek is a
then
father.
now we will be called upon to prove that Abdul Khalek of Khaliha and Abdul Khalek of Girwa, they are the same person. You are unnecessarily causing your own problem.
Because this was on record, so I annexed.
And
So that there is, I don't want
no,
to
even if
suppress
you
any
don't,
document.
you would have gone through the record.
My lord, anyway, the lordship would have gone through the record.
This is hearing or motion?
This is admission, my lord. LCR is under.
Lordship, can we go through the LCR once? I want to see what the reference is also about.
The this is which district?
This is Lord Nagaon.
The Deputy Commissioner Nagaon to cause an inquiry on the authenticity of the sale deed dated 27/11/1950 available at page 44 of the writ petition, as well as under what circumstance the circle officer had
42 years before.
passed the mutation order dated
75 voters, yes. Like 42 years before.
54. No?
The Jamabandi, my lord.
Ha,
It's below
dated
26/20,
26.
2020. Page number 52, my lord.
26/6/2022 in mutation case number NAG /SAM /2019-20/900 FMUT. The inquiry be caused as to whether Hamida Khatun, who is shown to be the daughter of A. Khalek, and whose name had been mutated, amongst others, in place of A. Khalek, is actually the daughter of A. Khalek of the 19.
Fatima Khatun. Hamida is the elder sister.
Fatima, huh?
Fatima.
Is actually the daughter of A. Khalek, son of Mullah Hussain of the 1965 voters list of village Geruahati, whose name appears at serial 112. The inquiry may be made through the Superintendent of Police Border Nagaon, and authenticity of the mutation order be done through the office of the Deputy Commissioner. Report on so and so for the this on so and so for the report.
Wife's name and the daughter's name is same or what?
Stepmother. Stepmother.
Because,
Sometimes, Verma, the difficulty in these proceedings is sometimes the unusual also actually happens. Sometimes the usual also does not happen. This is the most difficult part.
Lordship, you may record my submission. She's 56 years now. She's 66 born, so her name ought to have been there in some voters list preceding.
The Superintendent of Police to also verify that as the petitioner is 61 years as of now,
56 is shown in the affidavit.
is shown to be age 56 in the affidavit.
Yes, Lordship.
Why her name did not appear along with any other? That may not be very.
If you apply.
यहाँ पे की हो they get married before 18. So हम लोगों को पसंद इसको मानना है। ये तो नहीं था कि अपनी स्टेटमेंट से कुछ नहीं बोलो आगे। Yes, next time.
Item 12 for orders.
I for what purpose?
Delay in filing the review, Lordship,
How much?
and 1008 days.
1080.
He was in the detention camp and thereafter,
If it is per day 100 rupees,
Lordship,
if it is
because,
per day 100 rupees,
yes, Lordship,
how much it will be?
10,000.
1620.
If it is per day if it is per day 100 rupees,
Oh.
for 1000, how many?
Oh, 1,000.
1 lakh.
It's 1 lakh, so. It's not
Cost of 1 lakh, control.
he's not in a position. He was in the detention camp. This was also one of the reasons this delay happened. He was in the detention
So what,
camp.
it's a review petition or what?
Yes, Lordship,
Review.
review. And thereafter, Lordship,
Now, what's your ground?
Lordship.
Delay, detention camp.
Because of, he could not arrange for lawyer's fee, so later on he came to know about us, so we are providing him pro bono service, Lordship.
Yes, Mr. Ping, what is your submission?
My lord, the delay is 1,620 days as per my
One
calculation.
thousand six hundred.
620 days.
As per
And-
the registry lordship, because at that time,
We follow registry.
COVID also was there.
Understand, we follow registry.
Yes, lordship.
Apart from
We cannot follow the private litigation.
ignoring the COVID period, my lord, it may be 1,000 days. My lord.
1,000.
Apart from COVID period, my lord, if COVID period
This
is
is the order of which year?
2017, my lord,
17.
2017.
17.
11/5,
It is the
2017.
order of the High Court.
Yes.
Yes, lordship. And thereafter, immediately he was in the detention camp.
And he
19
was released in
December, he was released.
28/12/2019.
Because detention camp, it is easy to get a lawyer because legal aid
Because
service is immediately
service
provided.
It is
Now,
not-
it's legal aid is provided. Earlier, legal aid was not provided, lordship. Now it's was provided.
It is there.
Legal
Because-
Services Act was there.
That was there.
It was there, but not for declared foreigners, lordship. Even a person was behind the bar for 9 years, lordship, our litigation was before this court. The same question
Why
was
it was not asked for or not given?
not given at that relevant point of
Who
time.
did
in
not,
that
who did not give?
Because he was in the
No,
detention
who
camp.
did not provide for legal aid?
Because in detention camp,
Please answer.
yes, lordship.
If it was asked for but not given, who did not give?
Because he was inside the detention camp.
He
In
may be
another case,
inside.
I'm not telling.
Because we want to look into this aspect, because a serious allegation that a person asked for legal aid, he was not provided legal aid. So who refused it?
So he has not asked for.
So,
He was in the detention camp.
yeah, he was there, but.
Thereafter, when he came to know, then he approached us. So we have, before
It
this,
was
lordship.
always there. See, Niloida had started this long time back. Saying that it was not provided is a mark, bad mark on the judiciary.
Take a name, take a name. only. Mhm.
Dilip was behind the bar more than 8 years.
8 years, 10 years, we have Rohingyas there for 14, 15 years, they've provided legal aid, but there's no solution to bring them out. Always.
That I will discuss, ma'am, afterwards,
no,
because
that's what I'm
that I will discuss, because this is something different issue. Rohingyas is different issue here. And declared foreigner is a different issue.
If their claim is that, my lord, the legal aid was not provided, whether they filed any application for legal aid. If they filed, my lord, if it is not provided, then
Should make it happen.
So whether the scheme of this act, Legal Service Authority Act, can be extended to a foreigner.
my lord, this aspect was earlier, my lord, discussed. And now it is on, my lord, on humanitarian ground, it is.
Who had this? My proposal.
Well, in the numbers of cases, my lord, in,
You have to be specific. You are making a statement before the court. You just can't make a vague statement. If this come, who had this?
my lord, deliberated, but. it
Who
is
had
not-
discussed?
It is
You
not
say it was discussed.
probably. my
It
lord,
was
it is-
discussed between you and Madam Ghosh, or it was discussed between some authorities, or it was, who had discussed it?
my lord, let-
Have some patience, listen to what it is. Okay, the answer is there, what you were saying.
So when it was discussed,
Probably, my lord, in 2000, when there was a case, as per I remember, when my lord, the learned senior counsel and Dr. appeared with regard to that issue, my lord. Probably, but I don't have the record as on now, my lord, because I remember so far.
Searching about the prison.
what was the decision of the court at that point of time?
To provide legal aid lordship.
Uh,
But
provide.
it was not specified to declared foreigners of this, it was the condition of the prisoners in the jails who were not being provided along with legal aid, many other services. So senior counsel, Dr. Sir had taken it up and then this matter was decided.
Madam Verma,
Fixed lordship.
some of those petitions,
Lordship must have taken.
I had heard and passed some orders. That is not the relevant one for this purpose. Lordship is saying Legal Services Act is applicable only for citizens. As these people in the detention are declared foreigners, at one point of time, there was a thought process that they are not entitled to legal aid. The leader of the opposition had made an application to the Honorable Chief Justice raising this issue. And his lordship is aware of the actual facts, what had transpired. And thereafter, it was a decision was taken that this legal aid be also extended to this category of people. That's all. So possibly she is right that at some point of time it was not provided.
This can be, madam. But he was released, he was released in.
So now, Mr. Payeng, you tell us one thing. Condoning or non-condoning a delay, what is the origin of the concept of a delay being not condoned?
My lord,
Origin of the concept, mind you, take note. What is the origin of the concept of a delay being not condoned?
my lord,
As you are raising an objection, so we want to know from you. Because your objection has to be based on that concept.
my lord, the-
What is there anything in law that you go only by numerical figures? Delay of 20 days condone, delay of 30 days condone, delay of 50 condone, delay of 200 days and beyond, no condone. Is there any such a proposition? I don't think there it is.
it is,
So the figure doesn't matter whether it is 1600 or 1000 or 10 days.
it has to be properly explained, my lord. The delay has to be.
This is one aspect. I'm asking you, what is the concept of condoning a delay?
Concept of not condoning a delay.
Condoning or not condoning it? What is that concept? From where does it flow?
I have to go through, my lord, because
Firstly, statutory provision is the Limitation Act,
yes, that's
number one. And the underlying underlying concept of not condoning a delay is that because of the delay, a collateral right accrues to another party flowing from that change of position by the judgment to be impugned. And if you do not explain why there is a delay in approaching the court, because the collateral right or advantage that accrues to the other side will now have to be reversed back if that delay is condoned. So therefore, there is a requirement to explain why the delay had occurred, because you will be reversing. Now tell us in this proceeding, what collateral advantage, right, or something had accrued to the state by virtue of this delay. Suppose we condone the delay and reverse and condone the delay. What right or situation that the state had arrived at because of this delay would now stand reversed?
that aspect, my lord, we have to look whether.
No,
this-
you don't look, you
No,
tell us.
No, my lord, that's why,
Oh, has the state of Assam
whether
changed its position to any extent during these intervening 1600 days, which will now stand reversed if we condone the delay?
that is. That is.
What change had occurred to you? Suppose it's a property dispute. Somebody causes a delay of 1600. In the meantime, the other person who is the beneficiary of that order may say that in the meantime, I had done this, I have done that, I have improved the property. Now, if you condone the delay and hearing it, that advantage that accrued to me because in the intervening period will now have to be reversed. I have to be compensated. So that delay will be looked from a different point of view. But in this case, what change of circumstance has occurred to the state of Assam?
My lord, I have to get the instruction whether his name is there continuing. so his name may also be deleted from the voter list, my
You
lord.
have to include it.
Yes,
If the court interferes with this order, you have to include it.
and my lord,
You missed.
That will not give you a substantial change of position.
obviously, my lord.
Even if you read paragraph 35, I think, of that Union of India versus Tarsem Singh, where the concept of delay in a writ petition is dealt with. This, notice that there are three principles on that. First principle is every writ petition must be filed at the earliest without any delay. If there is delay, it goes against the. But the third principle is there should not be a corresponding change in circumstance of the other side because of the delay. If there is change, the delay may not be condoned also sometimes. But if there is no change, even after 5,000 days also, you are where you are only. This is one aspect, plus the effect that it may have on the person who had caused the delay. Suppose he is actually not a foreigner. We don't know. Only he is a declared foreigner by the tribunal. That judgment may be right, that may be wrong. If you dismiss for the ground of delay, is there not there is a possibility that a person who is actually not a foreigner will now become a foreigner?
My lord, my contention is that, my lord, if they are not, my lord, if in fact.
No,
it also,
you give legal submissions. We have already put forward all the questions. If you are serious in your raising the objection, you make your legal submissions. We'll hear you. When do you want to be heard? Tell us. You come prepared on the, we'll hear you on the issue of delay.
Before that, my lord, if I may.
Not before,
No,
after.
No, my lord.
First
before-
we hear the delay, then later
lord,
on we'll see other aspects.
If I may file a, my lord, objection of this, because.
Objection is not material. Your submissions are more material. You may make your submission without affidavit also.
Because, my lord,
objection
if the
also.
government, my lord, is ready to condone, then there is no.
No, we don't, we are not dependent on the government. We are dependent to make our adjudications.
And with instruction, my lord, whether any change occurs during this period, my lord.
I don't know.
So.
I don't know.
To bring that aspect only.
If you
there is
want
anything-
to make a legal submission, you do it either today or take a date. But don't raise all these ancillary things. We are not at all interested.
Well, let it fix, let it be fixed. my lord.
Mr. J. Paying, Land Counsel for the petitioner, objects to the delay of 1600 days.
Not 108 days, about 1,008 days.
1600 days, he stated. That is as per the registry. And we cannot ignore the registry order, madam.
Yes. Registry is 1,008 days,
You raised, what is the number of days as per the registry?
1,008 days.
Then why did you say 1600?
My lord, from original date of application.
Your calculation?
Yes.
No, we go by registry. We don't go by individual. A delay of 1,008 days.
1,008 days.
Little bit. One thousand eight.
1,008.
Full stop. Then council seeks for an adjournment to make his submissions on the concept of delay in a writ proceeding arising out of the foreign tribunals order. This council is so straightforward. You also come prepared? We'll hear you on delay. What is delay? What is not a delay?
Delay in review, my lord.
Delay in the foreign tribunal proceedings. Maybe anywhere. Because everywhere delay is, it's not a one concept. It's delay is a variable concept for different kind of proceedings, different kind of delays.
That's true, madam. Because in read petition, it may not be necessary. Delay, as your lordship already said, collection
Say,
conditions are there.
for example, today there is a delay in a service matter. A man is wrongly promoted. Somebody is aggrieved. He causes a delay of 1000 years. In the meantime, that man has been further promoted to another one. What will you do? Will you condone the delay and bring that man by 2 steps down? No. There possibly the delay may not be condoned also. It's a variable concept.
Time being item 8.
But Mr. Paying, we want a more exhaustive submission.
Yes.
Substantiated with relevant provisions of law, not just
Yes.
not just a oral
I'll
discourse.
definitely try my best to bring it.
Let us settle the issue. Mr. Nath, we wanted you, what is the police report that is?
The. Yes. Well, the first report is regarding the admission of that boy in the medical.
No, that will have to do it. We are not.
And the third page, kindly see. The
That
third
is,
page is the step. The investigation already, it is done. Now, they are at the final stage already, under the guidance of the supervision of the SP, serial number 5, notice to that officer has been sent under section 41A of CRPC. And case is pending for collection of further evidence, and the case is going to be submitted charge sheet shortly.
Before we were no research. We know the reason about the investigation complaining the oversight. The minor was illegitimate. Until writing, it could and so far comply. Now cases for further evidence that this is going to be something shortly. Present medical condition to understand seven years. So what is related to that medical report injury symptoms caused by blunt of the typically soft tissue injuries. Mr. Saikia, what is the exact medical problem of this boy?
He's not, his nerves are not functioning properly. He is not in a position.
Nerves are not functioning means he cannot walk or he cannot move or he cannot.
He cannot even walk.
He cannot walk.
Right.
Where is the problem in the body?
Personally seen him.
You tell us something more information. And any other medical problem?
No.
other than not able to walk? Psychologically, how is the
My
boy?
lord, he faints, my lord, after talking for few minutes, my lord, he gets pain. My lord, he cannot
Means
remember also.
he has lost the physical strength of
Well.
being. So he has lost the physical strength.
Clinical note.
He is having nerve problem. He is unable to walk. Madam Sharma, what does the medical opinion say? Can you ask the doctors what is their view?
Psychological problem is there, no? That report is there.
Report is
Report
there.
is.
Let us see.
Because
Because the police investigation has gone to the extent that injuries are simple, all injuries 4 to 5 days are caused by blunt object at that relevant point of time. Now, they have also possibly ruled out, they say no witness could be found who can reveal about the injuries being inflicted after he was released from the police. Because there was 2 to 3 days gap
Correct.
between he released from the police and getting admitted at Bogaigaon Hospital.
Correct.
Police investigation reveals that they could not notice any witness who said that he got the injuries after he was released.
release. Correct.
So, understanding is in the above circumstance, investigation turned up against complainant Inspector Deepak Saikia.
Deepak sir.
Very well.
Yes, sir.
So now I think section 106 will be applicable to Deepak Saikia. Only he can explain how it has to happen.
How it has happened. Lordship,
Because 106 is a fact specifically known to that person
that
concerned.
person consent. Correct.
Only he can tell.
Lordship,
And if he does not say anything, there is a presumption of law against him.
Lordship. Yes, sir. Section 41.
Suppose today, last night we were in the house of Mr. Saikia. Evidence is there, we were together. In the morning, an injury is found on you. Then 106 will be applicable against Mr. Saikia to explain how Mr. Nath had got that injury. Because there is nobody else in the house.
Yes, yes.
You don't expect any witness to come. And if he cannot explain, the law is against him.
Against
There is a presumption against him. So that 106 will be applicable
Yes.
against this police inspector.
Yes, yes. But he.
I think it is heading towards that situation.
Yes, yes, no, section
So
41.
now
this
we are
should-
deliberating, should we order for a judicial inquiry?
No, Judicial inquiry, if lordship.
See,
okay,
if you agree with any kind of compensation, suppose the state takes upon itself that yes, this happened in our custody. Because of this, the person is facing this medical problem. Then we can pass some reasonable compensation, what is normally passed against the state. State will be at liberty to recover it from that Inspector Deepak Saikia if we are so advised.
Yes, yes.
It's up to you, and also proceed and bring to the logical end of this investigation. Maybe we'll be monitoring it for some extent.
Mother.
Thirdly, this medical complication, you have to give continuous medical treatment to these boys,
Yes, yes.
whatever he requires. Medical says no significant neurological deficit. And you were saying neurological problem. If we have a more comprehensive medical report, then what had actually happened and what is more likely to happen. Suppose the medical opinion is that this boy will never recover from this state. Then we have to look at the problem from another point of view.
Yes.
Maybe we'll have to award some higher rate of compensation so that this boy always has the help of a helper or something to help him in his daily life. if he cannot get up from the bed, if he cannot go to his bathroom, if he cannot go to his dining room to eat, definitely he'll need a constant paramedical help. It has to be at that expense. Then the compensation will be of a little different way.
Different.
If it is something that has happened, but after some days he'll recover fully, then it will be compensation of that nature that normally what is awarded to injuries being caused in custody.
Correct. No, sir.
And medical problem, the doctors let them make their best effort to bring this boy back to normal.
No, sir.
And if the doctors are of the opinion that he can never be brought back to normal, means the damage is so permanent that whatever medical treatment is available, that is insufficient to bring him back to normal. Then maybe if you can have a medical report, it will help us in passing our orders.
Yes, yes. Yes. Now he is admitted at GMCH. The examinations are
He is
going on
already in
in GMCH. Now he is
an indoor patient.
Indoor patient.
he is now admitted in the medicine part. In the medicine
No, he is an indoor patient.
indoor patient,
Do you go to medical college?
in the first period.
Do you go to medical college? Not you. Inspector, we are not interested to hear for the time being. When the necessity arises, we'll hear you. Do you go at times? Hmm? If you go, why don't you look at the boy and form your own view and tell us? In your individual opinion, how the boy looks like. So we are more concerned with the what kind of the seriousness of the medical problem and what is likely to happen in future. Suppose this boy is absolutely disabled for the rest of his life. Don't you think it's a responsibility of the court to take care of that when he is before the court? We can pass our mechanical orders, pay a compensation of 3 lakhs and we'll also everybody feel happy. Yes, we have done a justice to the matter. He'll get it. But what will happen to him?
No, the
If everything was caused because of one night stay in the police custody, I think the society has to take care of this person now. And are we not a part of the society? All of us together. Hmm.
the-
Or you want to be accompanied by someone? No, you say you are going individually or you want to be accompanied by
My
somebody?
friend may go, madam.
No. We don't want to rely on it. You can give your information by visiting the boy to his house and telling us, because you are the counsel for the boy. This is like a court appointed commission. We don't want to involve it. Will you find it difficult? We're not compelling you. It's your own voluntary decision. Hmm. Because if you take a look at the boy, I think initially we were thinking of requiring the boy to be brought to the court. We ourselves would have interacted with the boy. So while he was being taken to the hospital or taken back, we have sought for a convenient time that on the way, please bring him here also. We personally would have taken a look. But now as he is admitted in the hospital, it will be improper to ask the
Yes.
authorities now to bring him to us
Correct.
and again.
Correct.
So that purpose we are requesting you. Hmm? Just take a look. You don't have to make an affidavit also.
Prima facie,
Tell us what is your opinion when you looked at the boy. If he's not that serious, we'll also not be that serious. If he's very serious, we'll also have to be very serious. That's all. And again, I'm asking you, will you have any difficulty? If not, I'll think of something else. Mhm.
Yes.
Today, what to be done?
Matlab,
Seen the status report dated 26/7/2023 committed by the IO in Bongaigaon PS case number 204/2023. List for further consideration next week give you.
No, it is the by the way, I have apply for the promo. Court wants to know the actual status of the year. How many people were there? How many years? Disposal of the
And updated medical status of the victim boy, we also made available on that. Updated medical status.
That's
No, next week.
in
Fourth
the in-
4th August.
in the meantime, madam will go and see person.
That will,
Lots of
that will think
lot-
about it.
Lots of. Let us see some 4th August. 4th of
4th
August.
August,
Lots of,
next Friday.
next Friday.
That is the doctor's seal.
Item 31 for hearing.
May it please the lordship. My lord, is this case, my lord. Can you see, my lord, page 26, my lord. My lord, here, my lord, the petitioner's father's name shown, as well as the grandfather and grandmother and other relatives. Well, the petitioner's father's name is serial number 464, Azimuddin. And his grandfather Tomezuddin, number 457 serial number. Then, my lord, kindly see the next 1970 voter list, page 29. My lord, here also is father's name shown, Azimuddin. Then, my lord, learned tribunal held that linkage is not proved. My lord, voter list of 1997, my lord, shows that, well, petitioner's mother's name is Atoshi Bibi, page 29, serial number 504. And my lord, voter list of 1997, paragraph, page 32, petitioner's name shown 187, serial number, is along with his mother's name, Otoshi. Then, my lord, petitioner examined one witness as his grandfather, my lord, as DW2, whose name appears in voter list of 1966.
Page number.
Page number 58, my lord. Tuazuddin. He also stated that the petitioner is his grandson, my lord. Page 59, paragraph 5.
Are you sure of what you will submit?
My lord,
Are you sure of what you will submit?
so far my knowledge, my lord.
Tomezuddin, son of Bideshi, is the grandfather.
My lord,
And you claim that DW2 is the grandfather.
grandfather's brother, my lord, grandfather brother.
Where is the name of Tuazuddin?
Tuazuddin,
At page 460. Very well.
26, my lord, page
Mm.
26.
This Tuazuddin is of village NC Pupkazia. And that Tuazuddin is of village Dokin Godhuni.
My lord, that earlier there was joint family in 1966, and he is
D, what is the distinguishing factor of a clarification, explanation, and evidence? What you are giving is a clarification.
my
Judgments
And-
cannot be based on clarification.
my lord, there is another document, my lord,
Now,
Jamabandi copies.
very well. This evidence was rendered in 2018,
2018, my lord.
66 to 2018 is 50 years. So if you add 50 years to 36, it becomes 86. So I think age is
88 years.
age is okay. But you show that Tawazuddin of NC Pupkaziya, the petitioner to produce any relevant material that Tawazuddin son of Bidesh at serial 460 of the voters list of 1966 of Village Dokin Godhuni and Tawazuddin, a resident of village NC Pupkaziya, who had rendered evidence as DW2 are one and the same person. Once you disprove,
My lord.
we can accept the evidence of DW2.
Also,
32.
But madam, but the age matches. Tawazuddin was 36 in 1966. He is 88 in 2018.
Yes, Lordship.
It will be
Shifting is also there, Lordship. From
only
K to
thing-
a non-K village.
only thing that whether it's the same person or not.
Yes.
2 weeks.
Yes, next item.
32.
Election Commission to produce all the voters list of the three places, Losanbari, Salapathar, Rapurpam,
Yes, sir.
where the years of shifting.
I have produced a relative. Lordship, in petitioner claims that he was in village Losanbari from 1966 to 1970, and thereafter shifted to Salapathar in 1970, and thereafter again in the year 1990 they shifted to Rampur Pam. And Lordship, I have submitted a voter list of Losanbari, Lordship. In the year 1966, the name of the petitioner, petitioner's grandfather, Akasali, son of Joinal, appears in serial number 103. Thereafter in 1970, Akasali name appears in serial number, your lordship, 88. But again in 1977 also his name appears. Although they have claimed that he has shifted in 1970. In 77 also in Losanbari, his name appears at serial number 112. your lordship.
So in up to 77, he is in Losanbari.
Yeah,
And after that,
Yeah, but in Salapathar, your lordship, in 1971, they have said that Akasali and Ahed Ali are the same person. But Akasali was there in Losanbari till 1977, your lordship, 1977. And in Salapathar, 1971, there is one Ahed Ali, son of Zainab.
Acha, Ahed Ali is already there.
Already there. in
So this
1971.
Akasali cannot be Ahed Ali.
It seems because your lordship,
Apparently, you're right.
in 1977 also there is Mewazan.
The Election Commission has produced a voters list of 1960,
Your lordship, 1966.
66, 70, and 77 of village Losanbari,
Losanbari.
as well as the
Voter list of
voters 1997 of
19
village
71.
70,
71 and 77
71, 77, and 97.
and 85.
Eight.
71, 77 and 1985 of village Salapathar.
Salapathar. The name of Akasali, son of
Son of your lordship, Joinal.
Joinal, appears in the voters list of 1966, 1970, and 1977 of village Losanbari. Thereafter, the name of Ahed Ali, son of
Joinal.
Joinal, appears in the voters list of 1985 of village Salapathar.
Yes.
It is claimed that Akas Ali had shifted from village Salapathar,
Losanbari to Salapathar.
from Losanbari to Salapathar, and his name appears as Ahed Ali instead of Akas Ali in village Salapathar. But by referring to the voters list of 1971 and 1977 of village Salapathar, it is pointed out by Mr. A. Ali, Learned Counsel for the Election Commission, that the name of Ahed Ali also appears in the voters list of 77 and 77 of village Salapathar. If it is so, it cannot be accepted that Akas Ali, after shifting from Losanbari after the year 1977, his name appeared at Salapathar as Ahed Ali, inasmuch as Ahed Ali existed at Salapathar even prior to that. Meaning thereby that Ahed Ali of 85 and Akas Ali of 77 Losanbari, Ahed Ali of 85 Salapathar may not be one and the same person. MSG goes, thank you, petition.
May I submit?
Seeks for an adjournment to examine the aspect. You are ready with the answer.
Yes, yes.
Very good.
My father's name is there in Solapathar Lordship in voters list of 1970. Father, Akas and Ahed is the grandfather, but father's name is there in Solapathar in 1970, Lordship. Father's name.
Then why are you referring to Losanbari then?
Losanbari, because 66, father is not there, no? So to bring the linkage from 66, this is the reason, because 70, father's name is there in Solapathar.
Let us
Father
see-
is
Let
Ainuddin.
us, which page number?
Lordship, I have with me, Lordship.
Even then, your lordship, if I may humbly submit,
Sorry,
if I may submit your lordship, in Salapathar, your lordship, in 1971 voter list I have submitted, your lordship. There Ainuddin is son of Ahed, and thereafter Rampur Ainuddin is son of Akas Ali. So
Yes.
they have relied upon the voter list of Losanpara because they are Losanbari, because there the name of Akas Ali is there.
Mm.
But in these two places, Rampur Pam and
I-
Salapathar, the father's name are, your lordship.
May I submit, Lordship?
understand. Do one thing.
Yes, Lord.
We have recorded,
Yes,
you
Lordship.
file your affidavit explaining this.
Yes.
Because otherwise it becomes very confusing.
I understand, Lordship.
Two villages-
File your affidavit.
Because.
We have already recorded what Mr. Ali had stated.
Yes,
You
Lord.
file your affidavit, we'll examine it.
Yes, Lord.
The voters list produced by Mr. Ali is kept on
Yes, sir.
record. Kept on record or you return it back to be
It's on
produced?
record. I'll photoshoot required also.
Item
You want
33.
6 months back, I think.
Did you?
This fact you analyze,
Yes,
put it in
Lordship,
a affidavit form.
I'll provide them a copy also.
Saji running Nessa.
Yes, Lordship. Father and mother's name appeared in 66 voters list. Father, mother and grandmother, 57 page number, Lordship. Motul Sheikh, father, Gole Nessa,
Notun Sheikh, new Sheikh,
Motul,
Motun, Mo.
Mo,
Motun Sheikh is the father.
yes, Lordship.
This is
Goleb Nessa is the-
1966 Gaon,
Duba
Dubapara,
Luptosar.
Luptosar. Very well. And Gole Nessa is the mother.
Mother.
Now, which method will show?
Adduced evidence, DW2,
Page number?
Lordship, page 51.
Uzirer Chor. One is
85,
Luptosar, one is Uzirer Chor.
Lordship 85, I like to take Lordship to.
Page number 85.
No, not 85, means 85 voters list.
Page number.
Page number 61, Lordship. Dubapara, Luptosar, Uziresar. These are two adjacent villages, Lordship.
Acha.
Both the name-
Dubapara, Luptosar and
Uzirer
Uzirer
Chor.
Chor, it may be the same. thing.
adjacent villages.
Earlier, it was a common list.
Yes, and it's adjacent villages.
Understood. No. In 1966, it must have been a common voters list.
Ah.
And the voters list is called Lupta Chor, which also included Uzirer Chor.
Yes, Lordship.
In 1985,
Please
they were split up. Koi is Lupta Chor, Khoi is Uzirer Chor.
Uziresar.
Same thing may have been split up into two.
Yes, and they are in this area.
But-
only.
As they are part from the part Uzirer Chor,
Yes,
therefore the person deposed as resident of Uzirer Chor.
Uziresar.
Yes, Mr. Sharma,
Structure by demand.
Aadhaar card.
Will produce. Will produce.
Third, MSD goes and all. that. Correct. The petitioner Sajid Nisa had been referred to the Foreigners Tribunal number
Number 8, Lordship.
Number 8, Gwalpara for
Gwalpara,
rendering
case
an
31.
opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT8, case number 895/2018. Tribunal rendered an opinion dated 19/3/2021, declaring the petitioner to be a foreigner, being agreed this writ petition is instituted. In the writ proceeding, the petitioner relies upon the voters list of 1966 of village Dubapara Luptachar, which contains a name of Motul Sheikh, son of Dukhi Sheikh at serial 143, and that of Gole Nesa, wife of Motul, at serial 144, where both are residing in the same house number 52. It is claimed that Motul Sheikh is the father and Gole Nesa is the mother of the petitioner. To substantiate that, the petitioner, Sajir Nesa, is the daughter of Motul Sheikh. Evidence had been rendered by Gole Nesa as DW2, showing her to be wife of Motul Sheikh and resident of Uzire Chor, wherein it is deposed that the petitioner Nazir Nesa is her daughter. As the name of Golu Nesa appears along with Motul Sheikh in the voters list of 1966, it can be accepted that Motul Sheikh would be a citizen of India. The evidence of DW2 establishes that Sajira Nesa is the daughter of Motul Sheikh. And from such point of view, also it can be accepted the petitioner has discharged the burden under Section 9 of the Foreigners Act 1946. A question would remain that Golu Nesa as DW2 had described her residence to be Uzire Chor, whereas the voters list of 1966 is of village Duvapara Luptachar. MS D. Ghosh, Land Counsel for the petitioner, explains that the voters list of 1985 would clarify the situation in as much as Duvapara Luptachar and Uzire Chor are adjacent villages who had a common voters list in the year 1966. But in the year 1985, it was split and indicated as the voters list of Duvapara Luptachar and Uzire Chor. Accordingly, it is thought to be established that Gole Nesa, wife of Motul Sheikh of Uzire Chor, is in fact the Gole Nesa, wife of Motul of the voters list of 1966 of village Duvapara Luptachar. In view of the remand, examine to the listing and also take note of the explanation regarding the aspect that the voters list of 1966 also included the village Uzire Chor, and that Golu Nesa, wife of Motul of Uzire Chor, had rendered evidence as DW2. The petitioner to produce the Aadhaar card of DW2 Gole Nesa to establish that the person who had deposed before the tribunal is in fact Gole Nesa of the 1966 voters list of village Duvapara Luptachar, stroke Uzire Chor. Respondents in the Home Department make their own inquiry and submitted the report, being the needful.
Deeply.
Can we further cross-examine?
Huh?
Can we further cross-examine?
If advised, the respondents may further cross-examine DW2.
Because DW2 is at present 82 years.
See, if something comes out of her, you extract it. If nothing comes out, she may say, I have lost everything. I don't remember anything. Then you are at the end of the road for you.
Duly cross-examined. It was in
And
page number.
If you want to
51.
cross-examine more, DW, as prayed for by Mr. G. Sharma, DW2 may be further cross-examined by the Home Department, subject to the condition of DW2 as of present. If DW2 cannot move, cannot remember anything, cannot speak anything, you can't compel that person. Because you had your opportunity earlier to cross-examine.
Deeply blessed.
Time being item 7.
I may be allowed to withdraw it.
What happened?
My lord, the 1971 extract NRC details, not voter list is there, madam. I will collect it and file it again, madam. Don't be allowed, madam.
It's a motion, first time.
Extract copy
No,
of
no, it's a, today is listed for the first time.
first time.
Mr. H.R. Chaudhary, then council petitioner seeks not to proceed this petition in the present form. Inasmuch as according to learning council, there is an inadequacy of materials being enclosed. However, liberty is sought for to file appropriate writ petition. Prayer for withdrawal allowed, liberty to file a fresh granted.
What like?
Timing item 9.
Lordship, in this
Nine.
case, Lordship, we need some more time, Lordship.
Mr. G. Sharma, like, Home Department pays for further time for bringing the records as required by the order of 8/6/2023.
Item 13 to 30 for hearing.
See, if possible, let us complete the order today.
Yes.
I think we have enough time.
Yes. Lordship is only clarifying certain points to be taken up by the DPC. Prima facie, Lordship is not upholding the
DPC.
orders of the same.
Regarding the adequacy or inadequacy, the DPC will look into that as well and take its
So
call.
basically, the judgment
13
is
to
uphold,
20.
because the Lordship will only clarify the.
No,
Nine. Okay.
we'll say whatever is provided, the earlier judgment stands modified accordingly. That's the language I intend to use. আপন করলেও এটা কমপ্লিকেটেড সিচুয়েশন হয় তাকে এটা কইছি কিন্তু রিজার্ভেশন করা নাই সেটা করে দিলে কি হবো we are not writing that completed judgment as written earlier. Obviously, some goal they can also mind if you know the provisions of this judgment to the extent it is inconsistent with the idea shall prevail and the judgment shall modified accordingly. This is the same maybe. What we intend to do, if I use the expression judgment is upheld, another gray area will remain. Somebody will say single judge has held this, division bench did not interfere, so it is there. If I write the word set aside, this judgment will be on a little different line. Then somebody will say that that has already been set aside. Whatever is provided here is the only thing and nothing beyond that. So what I will write is the provisions of this judgment
The Lordship will clarify.
shall prevail over the judgment of the learned single judge to the extent it is inconsistent. It is inconsistent.
Indicated will be, because
Ah.
modify the DPC has the habit of interpreting. Now,
No,
Lordship knows.
no, we'll
always
we'll
interpret.
make it very clear. DPC will only look into one aspect.
Yes.
Whether reserved person for that particular promotion in that promoted
Cadre.
cadre is adequately represented or not. If yes,
Yes.
reservation will not be applicable. If no, it will be applicable.
And the Sabarwal merit part will remain, because that's the core of our case. Because we came down for no fault of ours.
Frankly speaking, one is this reservation. Another one is those tax matters. It is so complicated, so vast, and it has been on
tricky.
the same issue. It had been dealt with by the Supreme Court on so many number of occasions.
Contentious issues.
Different branches, different this, everything comes out. So when you write a judgment, you can never make it comprehensive. Even if you try, something will be left out.
Yes.
Say yesterday in the tax matter we found. Even after the Supreme Court writing a judgment of 1000 pages on the, which supposed to be complete on that subject, still something was left out, and now it's a question whether the other one will follow or this one will follow. So better not
Because,
go into this.
because
thing.
your lordship will.
So why should I was thinking,
Yes, because
why
the DPC has the habit of, lordship will not give leeway to the DPC because already
so we'll be very specific.
we have suffered a lot since.
No, we'll
16.
see, we'll be very specific.
Very
And
specific.
see at the end of the thing, if you feel something to be changed, added, subtracted, tell us.
Because your lordship has rightly held in the equality forum, absolutely correct, that if the quantifiable data is to be made, the chief secretary, the government of Assam won't have any other job. Your lordship has rightly held that
Not
it will lead to absurdity. It is only the inadequacy of representation.
That's
which
the
has
only
been-
thing which remains.
Yes, that.
Only
And
thing
Journal
help
seems
us.
to has clarified.
In the meantime, 3 days have gone by.
Yes. Oh, now we are here to assist your lordship.
And that too, yesterday, I
Yes,
went
yes, for no
so
good
deep
reason.
into the tax matter,
Absolutely.
again, some
This-
portion has got deviated that side again.
This is the hazard of the profession. Lordship will assist.
You also take note, if you find something inconsistent, please point out. But irrelevant inconsistencies, please don't disturb in the order. This is number 1. Which can easily be, say, suppose one is should be R, don't correct all those things, we can do it at the end of the order also. But if substantially something is either deviated or left out, that, or something you feel the line ought to have been in this language and not that language, don't point out those things.
In fact, with the lordship's leave, lordship has rightly indicated, lordship will clarify the judgment. That will be, because modify order will, they'll get a leeway.
No modification, no
Modification, they'll
setting
get a
aside,
leeway.
nothing.
We clarify.
Any inconsistency with the judgment,
Yes.
this one will prevail.
Yes.
And whatever is not inconsistency, the other one will prevail.
And in
Judgment
terms
will
of the
prevail.
Supreme Court's order.
Schedule class that. Service manual, but directive, I don't know. Wait a minute. Copy this in and I 70 that and reservation in the portfolio was already provided for even prior to that. Actually, 77. I want to say in Assam, I think we can safely write that reservation for scheduled caste and scheduled tribe in promotion was already statutorily provided for
Yes.
even before the 77th amendment.
Yes.
Assam was
Assam
step
was
ahead.
ahead, 78 or less.
One from one. I think he was 14 degrees, so there was 1.1 for 14. Oh, judgment to stop. Judgment to. মই যিখন চাই আছিলো তাতে বিচাৰি নাপাওঁ মই নিজে চাই আছিলো বহি এখন আৰু হেৰি এখন দুটা বাইণ্ডিং কৰি থোৱা বহি আছে আৰু দুখনমান লিখিত আছে বেলেগ এটা সেট ললে আকৌ বিচাৰি নাপায় নিজে পঢ়া আন্ডাৰলাইন সেট কৰি আহি হয় এই যে বাইণ্ডিং কৰি যে থৈ দিয়ে আৰু তাৰ লগত আৰু দুটামান লুজ আছে সেইকেইটা নেকি বাইন দেখো সেইকেইটা A writ petition WPC 1560 2015 and 2680 2015 was instituted by who are they? Equality Forum. How do you describe them? It's a association or
Society.
are you sure?
Yes.
Just please check up your writ petition. What it was instituted by and it all over blank radio. In the name of Equality Forum, by a registered society, it's mentioned. Sorry, in the name of Equality Forum, a society. And 4 persons serving as assistant engineer civil in the irrigation department and seeking promotion to the next cadre of assistant executive engineer, comma, respectively. In both the writ petitions, an issue was raised that as per the judgment rendered by the Supreme Court in M. Nagaraj versus Union of India, reported in 2006-8 SCC 212, and UP Power Corporation Limited versus Rajesh Kumar, reported in 2012-7 SCC 1, there was a requirement of the state to have a quantifiable data on the backwardness and inadequacy of the representation of the reserved category candidates for the purpose of promotion. I think in broad words, that is the one. According to the two petitioners in the said 2 writ petitions, in the state of Assam, no process was initiated for obtaining the quantifiable data as required in M. Nagaraj Supra and UP Power Corporation Supra, and as such, further continuation with the provisions of reservation in promotion, as well as providing for consequential seniority, would be further unsustainable in law. In the said to writ petitions, as reported in 2016-1 GLQ 710, by the judgment and order dated 23/12/2015, in paragraph 47 thereof, it was provided that till the exercise of collection of quantifiable data relating to the three constitutional requirements of backwardness of the class, inadequacy of representation in public service, and overall efficiency in the administration in the event of reservation. As mandated in M. Nagaraj Supra and Uttar Pradesh Corporation with Supra, is done, and a formation of opinion by the state based on the quantifiable data so collected is formed as to whether the enabling provisions of Article 16(4) capital A is to be invoked, further reservation in promotion would remain in a dormant state. The relevant, the paragraph 47 of the Judgment in Equality Forum Supra report in Socha is extracted as below. In paragraph 67 of the Judgment in Equality Forum Supra, it was provided that the quantifiable data has to be both service and cadre specific, and what the one-man commission appointed by the government of Assam to collect the quantifiable data had done was that it had made a general statement about the backwardness of the scheduled castes and scheduled tribes, and had not provided quantifiable data either on the backwardness or on the inadequacy of representation for having regard to the representation, having regard to the promotional posts. It further provided that if upon undertaking the exercise of collecting quantifiable data, it was found that in a particular cadre there is inadequate representation of the scheduled caste and scheduled tribes, there was adequate representation, providing for reservation to such communities in promotion to such cadre would not be justified. In paragraph 68, it was of the same paragraph 33. It was provided that in the event reservation is sought to be introduced, then an assessment of the backwardness of the communities having regard to their representation in the promotional cadres would have to be carried out. Accordingly, in paragraph 74 of the Judgment in Equality Forum, it was provided that though the state had made provision for reservation in promotion by enacting the Act of 1978, which was amended in the year 2012. Implementation of the same would depend on acquiring the quantifiable data with regard to quantifiable data, which exercise has to be carried out cadre-wise in the context of the service where the cadre is placed. Accordingly, it was provided that reservation in promotion would have to would be justified, would have to be justified with the help of the quantifiable data to show presence of two of the compelling reasons, that is backwardness and inadequacy of representation cadre-wise and the cadre-wise, which would then have to be harmonized with the efficiency in administration as mandated under Article 335. Paragraph 74 of the Judgment in Equality Forum is extracted as below. Pursuant to the judgment dated so and so in Equality Forum Supra, the Government of Assam in the Department of Welfare of Plains, Tribes and Backward Classes issued the Office Memorandum number TAD/BC/2011/PT-1/PT-1/207, page 50 আছে না 50 of IV Dasgupta. এটিও বহুত আছে, especially WA46. Dated 3/8/2016, he issued the notification maybe. That issue that said notification. The opening paragraph of the notification dated 3/8/2016 provides that it was issued as per the guidelines laid down by the Honorable Supreme Court in M. Nagraj Supra and UP Power Corporation Limited Supra. Thereafter, in the first paragraph itself, reference is made to the one report of the one-man committee appointed by the Government of Assam for collecting quantifiable data, which was assailed before the High Court in Equality Forum Supra. And accordingly, the provisions of the judgment dated so and so in Equality Forum Supra was referred and quoted. The subject matter of the Office Memorandum dated 3/8/2016 is inverted comma, page 50 there say, review of government policy of reservation in promotion with reference to the Honorable High Court judgments, inverted commas, it's a court review. Will come back. The Office Memorandum dated next paragraph 3/8/2016 is extracted as below. Why the list is showing Bhagavan Pathar? Why the list is showing so and so versus Bhagavan Pathar?
IV Gohain,
Ivy Gohai. is the
Because,
appellate.
no, Bhagwan Patter, in the Bhagwan Patter's case, Ivy Guhai was never there. But Ivy Guhai wanted to make a submission in Bhagwan Patter's case, saying that her, because of Bhagwan Patter.
no. In this recent 46,
46.
where is Bhagavan Patel?
No, Bhagwan Patter was not a party. In the Equality Forum, Bhagwan Patter. In the Equality Forum. Sanjay Mohanty.
See, in WA 46, list is showing Ivy Gohai versus Bhagavan Patel. Item number 13.
It was showing for the simple reason because in the Bhagwan Patter's case,
Item number 1, Bhagavan Patel.
judgment was in Bhagwan.
Respondent number 1 is Bhagavan Patel. Respondent number 9, Obani Hazarika. Respondent number 10, Pranab Kumar Turung.
Yes,
All of them are reserved category candidates.
yes, yes.
Then Anil Kumar Jalan.
It is general.
Santanu Dhar.
They are general.
No. Why I am asking this question? Next, I wanted to write. Who instituted that petition challenging clause 4?
Bhagwan Patter,
Bhagavan Patel.
yes, on which the judgment was delivered.
So Bhagavan Patel is the writ petition.
Yes.
And then why are these people responded? Avani Mohan, Pranab Kurum, Anil Jalan, Santanu.
No, they were connected. There were several, because Lordship, I said, the clause 4, basically all reserve were brought down their seniority and
Understand.
everyone challenged it.
That I
Yes.
understand.
They were separate petition.
So Bhagavan Patel had instituted writ petition.
Originally, the main challenge is of Bhagwan Patter,
Where is that?
5005.
No, here an annexure is there somewhere.
Judgment.
Is it,
The issue judgment is
page 280.
152 in IB.
This is 152.
Yes, in readable 36. There is a summary of the litigation that is mentioned.
This is the order.
Bhagwan Patel judgment is
No, read the petition. So just a minute, Bhagavan Patel petitioner. Then Pushpak, Anil Jalan and Santanu Dhar respondent. One more writ petition, Equality Forum.
yes.
So there. Dinobandhu Deka, Deep Tegu, Nomeswar Tegu, Hidoy Boro. All of them are respondents.
Yes, sir.
So these are the two writ petitions. Only two writ petitions.
fact,
are there. Then
but-
why three writ petitions?
388 appeal means what had happened, one Santanu,
No,
some Mohanto.
Sanjay Kumar Mohanto,
you have filed
only one appeal.
writ appeal equality forum.
Equality Forum.
One writ appeal is filed by IV Dasgupta.
Yes.
Ivy Gohai and
IV Gohai Dasgupta.
the other is by Mr. Sanjay Kumar Mohanto. As I understand, Your Lordship, both of them were not parties to the earlier writ petitions which were disposed of.
But
They impeded
but
themselves by
they
way of an-
felt that they had agreed by the
Yes,
judgment of the
yes,
single judge,
yes,
so they filed a writ.
Yes, my learned seniors, yes.
Ah.
Appearing from this, appearing from-
And what about the other writ appeal? One more writ
The
appeal?
other writ petitions, Your Lordships, are factual.
No, not writ petition, then One more readable 239.
239
Equality forum,
it is
that
ours.
is yours, huh? No. No, understand, one more readable, somebody. pointed out.
That was also by change.
Item number,
Item number
21.
21.
sorry,
Sanjay Kumar Mohan.
21 readable.
Yes,
Sanjay
Sanjay
Kumar
Kumar Mohan, yes. Both the
Readable one.
readabilities are argued by my senior Mr. K.
No, no. The information I am having difficulty.
Yes.
Now I want to write, describe who all filed writ petitions. So one writ petition is filed by Bhagavan Patar,
Yes, the name.
0055,
Yes.
assailing clause 4,
Clause 4.
effect of clause 4,
Yes.
saying that the entire law in reservation had been kept in abeyance. Which
No,
not given effect.
entire benefit of merit in terms of RK Sabharwal was denied to the members of the reserve. That was my case.
No, that's why I wanted to look at the writ petition.
Yes.
Then the exact depiction will be
Yes.
more correct.
In fact,
Challenges clause 3 and 4 of the.
well, if I may take 5005
500.
and I read the prayer,
No, where do I get that?
that is. It is in the writ petition, it is annexed. Writ application.
It is annexed.
Yes, yes. Equality forum আছে ভালো।
In equality forum, your lordship, we have.
No, no, let us go one
Yes,
by
yes.
one. Bhagavan Patar instituted 5005.
500.
So where do I get that writ petition? Page number? Acha, you are holding Sanjay Kumar Mohan writ petition. So I am holding IG the scoop writ petition. Any idea page number? 21 to different.
প্রাইভেটও করাবে কোথায় করাবে প্রাইভেটও করাবে পয়সা নেবে
Hey, regular to teach you, how to find.
Yes, Lordship, IV Gohai, the Bhagavan Patar's petition is annexed.
Page number
At page, the operative part, the prayer portion is at page 75.
75. Hmm, 75.
Page 76.
Starts at page 50 something.
Malay-
50.
Yes,
53 it
it
starts.
starts at 53.
Immediately after that order.
Yes, and the prayers are there.
Very little, no? OM data কথা বলি, না? কি লিখবি? Below, The respondent number 1 in WA 46/2022, namely Bhagavan Patar, instituted WPC 5005/2016, assailing the clauses 3 and 4 of the OM dated 2016. On the ground that the provisions thereof had where exactly which paragraph? So that's some de-reservation.
Yes, Malad, we had challenged two things. One was de-reservation and the other was clause 4.
On the ground that the effect thereof had a de-reservation in the matter of promotion.
Because after post base, there could not have been de-reservation. Because
That is, that
Yes,
has effect of dereservation.
dereservation
in the
and clause
respect of reservation in promotion and
denial of merit to the members of the
and
reserve.
denial of merit to the reserved category candidates by in view of clause 4 of the OM regulations. Here there is no private respondent. From where it was Mr. Keen Chaudhary's client coming from? Because Bhagavan Pator, there is no private respondent.
Yeah,
They belong to the water resources department. They don't subsequently file separate.
Writ petition.
they were never a party.
Understand, they filed their own writ petition.
Independent. Water resources, they file petition there, I think.
No, that's why I'm.
If I may say,
Yes.
what has happened?
The reading facts is too complicated. We don't know who is filing.
Yes,
Because we have heard only reserved category, unreserved category.
Yes.
And state. But now who had filed which? writ
No,
petition?
actually, what has happened? The entire genesis started with the bringing of clause 4.
Hmm.
When we challenged it, the general thought, the judgment went in our favor. So the general thought, the promotions which were there due for us, we
General people, they are only appellants. They were
They-
never before the single.
no, they were before they were not, because the clause 4 was affecting the reserve. So reserve through Bhagwan
Understand.
Patar challenge.
What we have taken note of, that clause 4, firstly, there is a kind of dereservation. And
Yes.
secondly,
The merit was denied.
had been taken away because of clause 4.
4 and so
This is challenged by Bhagavan Patar
Patar.
in 5005.
Yes, that's the primary
Without
challenge.
there being any private respondent.
Yes.
So now, why the
Yes.
non-reserved
Yes.
people
Yes.
are before the?
Yes, I'll, well,
They are
when,
only at the stage of the appeal, or they were there at the stage of?
no, the general, what happened, my lord? When this clause was brought in, entire reserve lost their promotion, they were brought down, including Ivy, Turung and all. Turung.
No, we
So they challenged it. In that, the general came and said that we want that a clause 4, we should be given the benefit of
understand.
access.
Which writ petition?
Pranab Turung's case.
Writ petition number?
2999, I will ask it.
Those were the series of tag matters with.
No, then no, it's not that easy. The law is easy.
Yes,
it's
yes.
easy, but this I find it most complicated.
We had brought everything. In reply to IB provider, we had.
No,
brought
where is the impure judgment of the?
Page 76. my lord.
No. Single judge.
Judgment of them.
Judgment of this.
No, 150.
Where is the judgment of the learned single judge?
Yes,
Page
page 155,
155.
operative is 156.
150. No, now, when you take note of the judgment of the learned single judge,
Yes,
this is rendered in respect of 5005, where there is mentioned that one Anil Jalan and Shantanu Dhar are respondents.
These two were.
But the writ petition at page number, the one that I went just now, does not show any private respondent. So Anil Jalan and Shantanu Dhar got impleted later on or what?
yes, later,
Later on, they got
Yes.
impleted and they are general category.
yes.
And
And
they are
they,
trying to oppose that
The-
made by Bhagavan Patar.
Bhagwan Patar.
And other writ petition is 5026, Equality Forum. Here, some Dinobandhu Dekar.
Yes, and they were reserved. They implemented.
They are all made
Yes,
respondents.
irrespondent.
And you challenge the whole of the
Whole deal.
2016 on the ground that basic ground, many grounds of course. That in Equality Forum judgment in para 47 would say that it will be kept in dormant. But in spite of it, the 2016 had been issued,
Yes,
which does not indicate that it is being kept in dormant.
yes, yes.
This is the basic.
And we opposed it.
So from where does then Obonji, Hazarika, Pranab, Turung, they come in from.
They come in because
Anil Jalan, I got it. He got inflated
they
in
come in because
Santanu got
Turung
out.
was supposed to be the chief engineer of Assam.
No,
and
not
he
the
was brought
background
down.
side. How they come into the litigation?
That is the reason.
I'm not asking the reason why. How they come in? As a
Who?
respondent, petitioner, which petition?
No, they came in a separate writ petition when they were denied the promotion on merit.
Which petition?
The 2,999.
So you appear for IV Das Gupta.
Yes, Lord.
Why did you make them a respondent in this appeal? When this is a appeal against the judgment dated so and so in 5005 and 5026, where Bhagwan Patar is okay, he was
Bhagwan
a
Patar is okay,
petitioner.
yes.
Where Obonji Hazarika, Pranab Turun, they are not even involved.
Lordship,
Why did you make them a respondent in a writ appeal?
Lordship. Lordship, Honorable Justice A.D. Chaudhary, Lordship. The judgment that was passed in two cases, Lordship, only.
Understand?
Yes, Lordship. And in those two cases,
Mr. Das,
Yes,
this
Lord.
is what we are asking, Mr. Hazarika and Mr. Turun.
how they came,
It appears they were nowhere connected with 5005 and 5026.
no way.
So when you are filing an appeal against a judgment in those two writ petitions, why did we make them a party in the
Because-
writ appeal?
I was also not a party in those two writ petitions, 5005 and 50.
Mr. Das.
Lordship, I'm sorry, Lordship.
You are filing a writ appeal against the common judgment of the single judge in 5005 and 5026. If Hazarika and Turung were not a party in those two writ petitions, in an appeal filed against a judgment rendered in those two writ petitions, why did you make them a party in appeal?
Well, the Lordship.
This is what is creating all
Yes,
the
sir,
confusion.
because you're absolutely correct, because this is one of the main ground we took in the Ivy Guhai's writ appeal. Yes, when we filed as a respondent, when we filed our petition in opposition.
Turung and Hazarika is involved in any other writ petition.
Yes, which is still pending.
Those writ petition, they will be heard when we deal with those writ petitions.
Absolutely.
But when it is an appeal against a common judgment in 5005 and 5026, and Turung and Hazarika are not respondents there, why should they be a respondent in the appeal?
Because Lordship,
They are a stranger to this appeal.
they are stranger, because because they are the necessary party, your Lordship.
Why necessary?
Because if my case gets
In
allowed,
an
it will be affected,
appeal, the
Lordship.
only necessary party is the parties who were involved in the earlier proceeding. No one else is necessary.
That's why,
party.
Lordship, we have filed a leave application also, Lordship, that has been allowed, your Lordship.
Why did you file? He may have been allowed, he may now discard it also. Only merely allowing somebody wants to come, let them come. How can you file leave application in an appeal filed by?
Because they are the necessary party, that's why.
Why necessary party?
Because, Lordship, if my case gets allowed, this like this, Ivy Das Gupta,
Suppose IV we are completely allowing, we set aside single player. So
Lordship,
they are necessary party. What?
because they will be the agreed person, Lordship.
Why are
Will be
you
agreed
bothered
by
about a stranger?
Because
See, litigation is only between the parties involved in the litigation.
I totally agree, Lordship.
Somebody else may be aggrieved. How do you know? That is firstly. Secondly, it's a matter of concern of that person. If
Absolutely.
somebody is aggrieved, they should come forward to the court. How can you make them respond?
In fact, the issue, Lordship, the issue upon which the honorable
Issue
the
may
judge,
be anything. See,
technically, Lordship,
See.
it was.
Mr. Das,
Yes, Lordship.
suppose today we are dealing with those foreigners tribunal.
Hmm.
Today, I decide a particular question of law. Do you mean to say which may have a bearing
Hearing,
in almost all the writ petition?
Lordship.
Do you expect I am supposed to issue notice to every writ petitioner, every respondent of the pending writ petition?
No, Lordship.
Because my decision may affect them.
No, Lordship, that is.
Are you not following the same principle here?
Lordship, because what is my understanding was that, Lordship, the
understand your
matters will
understanding.
take your Lordship.
But are you not bringing?
Technically,
this
Lordship
idea?
is correct. Lord.
So we delete these two.
Absolutely. Because this is the ground I have taken. that there is no lease. You were never a party. Bhagavan Patar was in the cadre of system,
So-
so Ivy was chipping.
So wherever there is a petition of Hazarika and Turu, we'll hear them. Whatever they have to say. This is the basics of legal.
And in fact, now
In
everyone has
appeal-
reached that.
In appeal, the only parties would be those who are parties in the order against whom the appeal is.
This was the ground taken by us, that you are a stranger.
Lordship,
By which order they were impleted, let us. See.
Lordship.
They were never implemented. No, they were never
It
implemented.
says that there's a leave granted by the court. Let us see what,
Lordship, by 31/2023, your lordship,
let us see.
the order, your lordship.
You want to read the order by which leave was granted?
Lordship, it's not in the, I couldn't trace it,
These
lordship.
are
The file has become so bulky.
unnecessary, our time is wasted. Maybe you could drop these.
Lordship,
So has to
permits
be
me-
correctly written. We can't,
Lordship, permits, lordship, may I check the?
they give the number, court master will find it out.
Yes, lordship. It's item number is lordship,
It's not item number.
leave application number.
Order by which leave was granted. Application number,
And
date of
order,
the order.
lordship, give me kindly sometime, lordship, I will just. trace it up.
কি লিখলি? এই শ্রী ভগবান পাতার had instituted on the ground that on the ground that the effect thereof was that de-reservation in respect of promotion had been made. And secondly, the merit,
The clause merit, which is due to the reserve.
the merit, the promotion on the basis of
No, merit
which
in terms of
the
RK
reserved
Sabarwal.
category candidates had been taken away.
Taken away.
Court start করেছিল। তারা তো court start করেছিল।
Respondent number one.
না, না, তারা করতে। The respondent আছে। The Society Equality Forum, which had earlier instituted WPC,
Five zero two six of
50, no, which had earlier instituted the writ petition resulting to in the judgment dated 23/12/2015 in Equality Forum Supra, had instituted WPC 5026, assailing the entire office memorandum dated 3/8/2016 on the ground that in paragraph 47 of the judgment in Equality Forum Supra, it was provided that the reservation in promotion would be kept in a dormant state till such time the quantifiable data is collected by the state in respect of backwardness, backwardness and inadequacy of representation of the reserved candidates in the reserved candidates, as well as no, that the one particular language is used, as well as that it would have to be harmonized with the efficiency in administration as mandated under Article 335. IAS civil from Kihot, appeal return. This is IAS civil in writ appeal or in writ petition? In the writ appeal. Straight for seeking leave to file an appeal. An applicant is IV Das Gupta. IV Das Gupta was not a respondent in 5005. So IV Das Gupta feels that I am aggrieved by the judgment.
Yes.
So seeking leave to file an appeal.
Yes, my lord, we took, actually what had happened, my lord, all these cases were heard together. The learned single judge, like a reference court, answered in Bhagavan Patar's case, dealt with the same issue, my lord, which are involved in our case. Therefore, we filed a writ appeal by taking leave from the onward division.
You are some other petitioners.
Yeah, my lord, in one case, I am representing that IV Das
IV
Gupta.
Das Gupta.
Or why? And in other case, I am representing Sanjay Kumar Mohanta. These are the two cases, my lord. One from Water Resource Department and other from Irrigation Department. My lord, because our cases were not dealt with, but we are nevertheless were aggrieved by the judgment.
Agree by the conclusion in the judgment, but the repetitions were not dealt with. So you filed appeal against the judgment, and by
After
this,
taking leave from the
so
honorable.
you have taken leave from the court
Yes.
for filing, and ultimately this appeal is before
Right.
us.
Otherwise, my
No,
lord,
no.
fact-
IV Das Gupta can file writ appeal.
Huh.
We have no difficulty. But why did you make Oboni Hazarika and Pawan Turung to be respondent?
no, my lord, they are also the reserve category candidate.
Why did you make a respondent? If they are aggrieved, they'll also file their appeal.
No, there is a writ petition, my lord, 2999.
No, understand. We are putting this question because it half an hour we wasted for this one on the parties. For the issues, we are clear. 5055 is filed by Bhagavan Patar only against state respondents, no private respondents.
Yes,
5026 by Equality Forum, there some private respondents are there, but none of these people.
because I made them.
Just a minute. So none of these people. There is a judgment passed, common judgment in 505 and 5026.
Not a common judgment, it's an inter-party judgment in that case. But we are all agreed by the judge.
No, by one judgment,
Yes.
there is in respect of two writ petitions.
Ah.
So if you are aggrieved by this judgment, a person aggrieved who is not a party in those two. writ
Because my lord, just,
Those two-
I have understood the question, I was trying to answer.
Let me complete it. Those two, if you are not involved in party in those two writ petitions, but you feel you are aggrieved, under the law, you can file an appeal.
Hmm.
So therefore, IV Das Gupta seeks a leave to file an appeal.
It's okay.
To that extent, no difficulty.
Why Pranab Turung?
Why Gurung had been made a respondent?
Because Pranab Turung was in
If
the,
Gurung and Hazarika, they are aggrieved by the same judgment,
Huh.
they will also seek leave like IV Das
No,
Gupta
my
and
lord.
come before the court.
Turung is not aggrieved. Turung is a beneficiary of the judgment.
So why will you make Turung?
Because my lord, in IV Das Gupta was a respondent in the writ petition filed by Pranab Kumar Turung. That is why my. In Pranab Kumar Turung's writ petition, IV Das Gupta was a respondent. That is how my.
Because of the effect of the judgment in two writ petitions,
Yes.
where they are not a party, IV Das Gupta files a leave for appeal, leave is granted.
Yeah.
But IV Das Gupta is a respondent in a petition filed by Turung and Hazarika. So
That
as
is how.
you are IV Das Gupta is filing appeal against that judgment,
Yes.
which is affecting her rights or in any manner she is affected. You also include Hazarika and Turung.
Yeah.
Because why? But this is where we are having slightly differing with you. If IV Das Gupta is in any manner affected by the judgment in 5005026, IV Das Gupta can always seek appeal. But this seeking remedy is unconnected with the petition where she is a respondent.
No, my lord, supposing, my lord, I'm just
No,
giving
no,
an example.
suppose we decide in favor of Ivy Das Gupta.
Yes.
Ivy Das Gupta exercised her own right to file an appeal because I am aggrieved. She gets an order in her favor. She'll enjoy the order. If that enjoyment affects somebody else, it is for the Turung and Hazarika to come before the court that say that please include us also.
No, my lord, supposing lordship allow,
No, because appeal is in only respect of two writ petitions, not with that other writ petition of Hazarika and Turung and this thing.
no, technically lordship is correct because I
now
want
we
to
can-
intervene in a proceeding.
No, now we intend to delete this Obani Hazarika.
No, opponents, lordships can delete, there is no problem.
Turung also
But
delete.
what Turung lordship will not, because Turung, supposing my lord, if a lordship allows our writ appeal, then it is the Turung who will be aggrieved by that.
Then Turung.
No, no, but today Turung is not aggrieved by the judgment in
Understand.
Bhagavan Pator.
Understand. So then Turung will file a review against that order. For what may in future happen to.
But I was just trying to understand, subject to correction, my lord. What is the prejudice that Turung will suffer if he is implemented as a party? I'm just
No, but
thinking,
the basic is,
because
no, the basic is in an appeal.
tomorrow, supposing my lord,
Tomorrow-
no, I'm giving an example, my lord, kindly
no.
appreciate. Tomorrow,
I understand
tomorrow,
your
supposing lordship allows my writ appeal. And I don't make Turung a party. Then Turung will go to Supreme Court and say that he is a respondent in my writ petition, he didn't make a party, he sought leave.
No, this is where we are differing. Ivy Das Gupta has sought leave as Ivy Das Gupta because she is aggrieved by a judgment rendered in.
But I am not aggrieved against Bhagavan Patar, I am aggrieved against Pranab Turung. Bhagavan Patar is in a lower category, my lord. Different cadre.
Mr. Jogi, please understand. Basics of a party is, but unnecessary for this debate, our judgment will not be complete now. I actually today.
Lordship can keep this issue for a moment, my lord. Lordship can proceed with the judgment. If necessary, my lord, on some other time, we can debate on that, my lord. That's my humble submission, of course. Lordship can keep that issue for the moment.
Disturb the mind.
If I
Unless the
may-
things are not sorted
If
out.
I may submit, my lord, he is right because the Pranab Turung was aggrieved because he was brought down
No.
and he made
Mr.
Ivy.
Let me put the question in a more straightforward manner. Who is a party in an appeal? The persons who were parties in the order against which.
Not normally.
That is normally. First abnormality is if an or judgment passed in the repetition of somebody else. A person is aggrieved or some of his rights are affected. He can always file leave to file an appeal against that judgment. Ivy Das Gupta, I'm again clarifying, please. Just a minute.
I have an answer, my lord. I have an
Mr.
answer.
Chaudhary, your answer comes before my question. Just listen. Ivy Das Gupta as an individual is affected by this judgment. So she comes in with a leave application that I want to file an appeal. Ivy Das Gupta has two status. One status, she is an individual who is affected by this judgment.
On principle.
Other status, she is a party in another writ petition, where she may be a respondent, she may be a petitioner. That petition will be decided on its own merit. If, just a minute, if any of these conclusions arrived in this writ appeal affects that writ petition, it will be binding. If it is by the binding nature, if you are aggrieved, you will file your own petition assailing that judgment. So Ivy Das Gupta as a respondent in a writ petition will always have that right. But when Ivy Das Gupta as an individual being affected by a judgment is seeking leave, she did not carry a baggage of carrying everybody in her
In
repetition,
that case, my lord, lordship will keep that option open.
possibly.
Because in
What
lordship
you are-
will be deciding the principle.
What you are doing is doing it in the utmost of fairness, but
Yes, in that case, my lord, my right qua to that lordship will keep open.
that we are anyway not touching.
Then
And
it's okay.
even if we touch, we are going to hear it
Then
separately.
it's okay. Then it's okay.
Because this is a
I follow that.
judgment only in respect of two repetitions.
Lordship will, that if tomorrow supposing my lord, my writ appeal is allowed, then my lord, I have no problem. On principle, lordship will answering the reference in a manner we are asking. In that case, to will be agreed. But otherwise, my
No,
lord,
no, a two rooms repetition will be heard separate.
okay. That will lordship will keep open. That means 2,999 will
It will be heard separately. And if any of the law decided in this appeal is also applicable,
then in
will
other
be
appeal also same principle will apply. my lord.
apply and two room will do it accordingly.
Well, in other appeal also same principle will apply.
Suppose today,
No, I followed my lord.
two strangers have filed a writ appeal, maybe involving the same legal issue. They get a judgment and my single petition is pending. I am bound by that judgment.
Yes.
And whatever I am required to do, if I am agreed by somebody else's principle decide, Turu will follow that procedure.
Okay.
And Ivy Dasgupta will also follow that procedure in that writ petition.
Yes. That means lordship will keep my writ petition qua to open. Open. Yes. Same principle will apply in the second appeal also.
If everybody agrees, we want us to decide, we'll decide it, but separate.
Okay.
Once this is complete.
Yes.
If you feel that no, we all like to go back to the single bench, we'll go back.
Well, I think that is okay. I'm deeply obliged.
Understood.
Well, I'm in the midst of a matter in court number 1. Deeply obliged.
But otherwise, what will happen tomorrow, another kind of this kind of implement.
Me join there of parties and all.
So this order, say the High Court has allowed it.
Yes, there is an element of misjoinder of parties.
That will
Correct.
be correct. Because somebody who should not be allowed to come in, if they may rely on this one and say that it was a day occasion allowed.
Deeply obliged.
Resulting the receiving the entire on the ground that
It was kept in dormant, no?
it's a stand by quantifiable data is collected by the state.
Backwardness, Omuk, and also that efficiency. The two writ petitions 5005 and 5026 for 26 was decided by the learned single judge by the judgment and order dated 6/6/2020. Where is the conclusion?
Lord,
Where is the conclusion which can? Get
Bhagavan
into
Patras,
in this judgment?
yes, Lordship, the conclusion.
Which paragraph specifically?
My lord, it starts at page 190,
190,
uh,
para 7.
no, para 3.
Para 7, I think the aforesaid determination
Yes,
can be
but
summarized with the following.
But he looks in the learned single judge talks about the merit part in just above it,
That we have
in
quote,
3, clause 3. Roman 3. Because if its logic was the 78 Act, power flows from it, it is still there. So the state is not within its competence. Well, like he, 189. 189, clause D.
Without going into the arguments and counter arguments that were raised by the respective parties in the aforesaid two petitions, we take note of the determination that had been made by the learned single judge in the judgment of Reddit, which is at paragraph 7 of the said judgment and extracted as below. Describing somebody else's judgment is most dangerous. So better quote it.
Yes.
Because we are going on to totally something else.
Yes.
So why unnecessarily create a?
Yes.
In paragraph D bracket 3 of the said judgment, it had further been held as extracted. What did the single judge say about equality forum claim that it should be kept in dormant?
Regarding dormancy, your lordship, in fact, regarding dormancy, the learned single judge didn't go into, only he said that given the dictum of after Janelle Singh, the equality forum is redundant, rendered redundant on regarding backwardness. At page 191, Roman 7.
From the aforesaid extraction of the judgment or detail of learned single judge, it is discernible that in respect of the challenge to clause 4 of the OM dated 21/2016. It had been provided that the policy of providing reservation in promotion with consequential seniority being holding the field as per the OM dated 12/3/2002, comma, the state is not within its competence and jurisdiction to deprive such benefit to a meritorious reserve category candidate, and that too without expressly bringing such policy by superseding the benefit granted under the OM dated 12/3/2020. As regards the challenge of the Society Equality Forum, as regards the entire OM dated 3/8/2016, it had been provided in paragraph 7, Roman E, that given the determined General Singh. General Singh versus. Two General Singh, with General Singh 1.
Well, this will be Janelle Singh 1.
that para 7.
Yes, and the second is the, on the inadequacies, General Singh too.
In General Singh versus Lakshmi Narayan Gupta, reported in 2018, 10/63/96. The judgment dated so and so, rendered in Equality Forum Supra, has become redundant. In other words, by the judgment dated so and so in WC 505 and 5026, the learned single judge firstly held that clause 4 of the OM dated 3/8/2016 has to be interpreted in a manner that the policy of reservation in promotion with consequential seniority having been provided by the OM dated 12/3/2022, 2002. It is beyond the competence of the state to derive service benefit to a meritorious reserve category candidate without superseding the earlier OM dated 2000. And with regard to the claim of the Society Equality Forum, that although in para 47 of the judgment in Equality Forum Supra, it has been provided that since the quantifiable data is collected, the policy of reservation shall remain dormant. But that provision of the judgment shall not hold good in view of the subsequent judgment of the Supreme Court rendered in General Singh Supra. IV Gohai Dasgupta, who is an unreserved candidate and is a respondent in a writ petition WPC.
Two triple nine stroke 2020
Had sought leave to file an appeal had instituted IS Civil 2003/2022 to file an appeal. This IA is in which case? The IA cannot stand independently.
Was against filing number.
Uh,
It was against the filing number.
Okay, writ appeal is filed and along with that. Instituted IS Civil 2033/2022, seeking the leave to file an appeal against the judgment and order dated so and so in WPC 5005 and 2026. On the ground that the conclusions arrived therein had adversely affected the legal right of the said applicant. And along with the interlocutory application, memo of a writ appeal was also presented before the registry, which remained unnumbered at that stage. The IS Civil 2033/2022 was given its consideration by the order dated 31/2023, granting leave to IV Gohai Dasgupta to prefer an appeal against the judgment and order dated so and so in WPC 5005 and 5026. In the circumstance, WPC 46, WA 46/2022 had been registered. Some of the unreserved candidates had instituted WA 162 stroke 2023, also being agreed by the judgment and order dated so and so in WPC 5005 and 5056. We don't go into that question once again whether they are not. It will take another 1 hour. To solve.
Yes.
Forget about that. They have instituted, let it remain like that. The Society Equality Forum, who was the writ petitioner in WPC 5026 2022, 2022, had instituted a writ appeal, had instituted WA
39.
39.
39 of
39 stroke 2023. 2022. For on their own grounds, being agreed by the conclusion of the learned single judge as regards their plea that in spite of the judgment in Equality Forum Supra in para 47, reservation in promotion had been kept in a dormant state without collecting the quantifiable data. But by the OM dated 3/8/2023, reservation in promotion was allowed in some manner without collecting the necessary quantifiable data. People own ground, by their own. What you
OM of 25th has been.
Huh?
OM of 25th should be OM of 2016. Correct.
Huh?
That was.
OM of 2016.
Yes.
Well, I said 20. 3/8/2016.
3/8/2016.
Third, Mr. K. Chaudhary, Learned Senior Counsel, assisted by so in WA, as well as Mr. M.K. Chaudhary, or your name.
No, my senior.
M.K. Chaudhary, Learned Senior Counsel, assisted by in WA is at 39. Mr. D.K. Das, Learned Counsel for the respondent Bhagavan Pathak.
Yes, Bhagavan.
The respondent Bhagavan Pathak. As well as Mr. D. Mojumdar, or who appeared? Mr. Mojumdar appeared, I think. Learned Additional Advocate General for the state of Assam for the state respondents. Mr. K. Chaudhary, Learned Senior Counsel for the appellant Ivy Gohain Dasgupta and the other appellants. You are also there. 162 assisted by Mr. Chaudhary is also there.
Yes. One of the.
It took a count to liquidity. You are for some respondent. Reserved or unreserved? Reserved. For the appellant, Ivy Gohain Dasgupta and other appellants in WA 39 to 162. 162. Has raised a contention that by the OM dated 29/12/2014. Consequential seniority meted to the reserved category candidates by the earlier OM dated 2002 diplomacy. 2002 by the earlier OM. The 12/3/2022. 2000. Sorry, 2002 had been superseded. Meaning thereby that the provision of consequential seniority pursuant to the enabling provision of the Constitution 85th Amendment had been withdrawn. Accordingly, Mr. Ken Chaudhary yields the conclusion of the learned single judge in the judgment dated so and so in WC so and so. As regards clause 4 of the OM dated 3/8/2016, that as consequential seniority itself had been withdrawn by the state authority, no further question remains on any claim of the reserved category candidates as regards their merit consideration. Pursuant to their consequential seniority. What was your other submission? This is one main submission I noted. So it is not there at all. What was the Mr. Chaudhary's other any other submission?
No, it wasn't. In fact,
I think this was the,
this was the gist of the submission. It's a very small, narrow approach that you're taking.
because he had referred to that the clause 1.11 and then the 14 of that OM then say,
Yes.
reading the two clauses,
Yes, yes.
Mr. Chaudhary substantiated his contention by referring to clauses 1.11 and 14 of the OM dated 29/12/2014, with a submission that a conjoint reading of the provisions of the state to clauses would make it apparent that the earlier provision of consequential seniority meted by the OM dated 12/3/2002 had been withdrawn. It is also the submission of Mr. Ken Chaudhary and Senior Counsel that consequential seniority is pursuant to an enabling provision under Article 16(4)(a) of the Constitution, as introduced by the Constitution Amendment Act, Constitution 85th Amendment, and therefore, it being an enabling provision, it always remains a discretion of the state authority to withdraw the consequential seniority as per their requirement. Mr. D.K. Das, learned counsel for the respondent Bhagavan Pathar, on the other hand, per contra, contends that clauses 1.11 and 14 of the OM dated 29/12/2014, even on a conjoint reading, do not indicate in any manner that the consequential seniority meted by the earlier OM dated 12/3/2002 has been withdrawn. Mr. M.K. Chaudhary, learned senior counsel for the Appellant Equality Forum, on the other hand, has raised the contention that The provision of paragraph 27 of the judgment in Equality Forum Supra
47.
47 in Equality Forum Supra was explicit enough to provide that till such time the quantifiable data on the elements of backwardness and inadequacy in representation, coupled with a harmonization of administrative
Efficiency under Article 335.
what efficiency?
Harmonization of efficiency of administration.
Administrative efficiency
Under Article 335.
under Article 20.
Of the judgment equality for the explicit enough to provide that till such time that.
But as no collection of any such quantifiable data has been put on record, therefore, the embargo provided by paragraph 27 of the judgment in Equality Forum prevails, and no such reservation in promotion can be, no such benefit of reservation in promotion can be given to any of the reserved category candidates, let alone giving any consequential seniority.
Paragraph 47, Your Lordship. Okay. Yes, I'm apologizing.
These will be corrected.
Yes, I'm sorry, I'm apologizing.
Don't be concerned with those small trivial.
Yes.
And mind you, it's not so easy to
Yes,
remember so many figures at the same time.
Yes, absolutely.
Try to remember. I don't think you can. And with these things, you don't be concerned at all.
No.
It is time corrected.
But there's no collection of at least.
Mr. D.K. Das, Land Council for in Equality Forum, for whom do we appear? For the respondents
Reserve.
who are all reserved category candidates. Raises the, per contra raises the contention that in General Singh, where is the second General Singh and Povitora second? That second. No, second. In General Singh and others versus Lakshmi Narayan Gupta and others, in Civil Appeal 629/2022, the Supreme Court by the judgment and order dated
28 January 2022.
28
January
1, 2023.
2022.
In paragraph, which paragraph?
Paragraph 47.
In paragraph 47, had provided that, but that the backwardness is inherent.
No, that is not, it talked
That
about
is the
the
poster.
rosters are always cadre wise, not group wise.
No.
That is Journal Singh one
No, one was backwardness,
for backward.
and there is a presumption in law that backwardness exists.
Yes,
So you don't need quantifiable
No.
data. Where is that provision?
that is in one.
One,
General
not
Singh.
in two.
No,
One, which
two is on inadequacy.
General Singh two. Then
Yes.
why this Povitora there?
Povitra is on efficiency.
And General Singh two is on
Inadequacy, that it has to be always cadre wise.
inefficiency,
Cadre wise.
inefficiency, backwardness.
Yes.
One on backwardness, two on inefficiency,
Inadequacy.
inadequacy,
And three on Povitra,
Povitora
on efficiency,
Inefficiency.
inefficiency.
General Singh one. By reference. By referring to change.
The Supreme Court, but it is not ordered.
Yeah, okay, yes. By referring to a judgment, the Supreme Court,
There is a contested taking judges, say, another.
General Singh and others versus Lakshmi Narayan Gupta and others. Reported in 2018, 10 SUC 396.
Paragraph 36.
In paragraph 36. Had provided that. That. The. That. The provision in Nagaraj Tukra, Nagaraj Corporation, it has been put. Provision in Nagaraj versus
Union of India.
Nagaraj and others versus Union of India and others reported in 2006 8 STC 212. Providing for that, the state has to collect quantifiable data showing backwardness of the scheduled caste and scheduled tribe, being contrary to the 9-judge bench in Indra Sawhney versus Union of India, reported in 1992 SUPP bracket 3 SCC 217, comma, is held to be invalid to such extent. Accordingly, it is contended that the Supreme Court in General Singh Supra had held that there is a presumption of backwardness in favor of the scheduled caste and scheduled tribe communities, and therefore there may not be a further requirement to obtain any quantifiable data to substantiate their backwardness. Mr. D.K. Das, Learned Counsel, also refers to the judgment of the Supreme Court rendered in Agurbal Additional Nagraj reported in civil appeals. In civil appeals, so decided on so and so. Decided in so and so. Wherein in paragraph 47.
Yes, 47.
In paragraph 47. It had provided that the collection of data as regards inadequacy in representation of the reserved category candidates would have to be done cadre-wise, not group, which is a part of a group. And cadre-wise. Accordingly, it is the submission of Mr. D.K. Das that as the collection of data as regards inadequacy would have to be done cadre-wise, which again would mean cadre-wise and service-wise, service and department-wise. Therefore, there cannot be a centralized procedure set in place for collection of the data regarding inadequacy in representation. And such inadequacy would have to be determined cadre-wise and case-wise in respect of every such promotion under consideration to any given cadre. It is also this contention of Mr. D.K. Das, Land Counsel for the reserved category candidates, that the Supreme Court in But it's provisional second.
DK Pavitra.
No, one for Pavitra, second. No, yes, second. Second to second. Yeah, the man. You have to go on a field, right, marker. Oh, just second. That the you call it that that the Supreme Court in BK Pavitra and others reported in 2019 16 SCC 121 in paragraph
123
123
to 126.
to 126 had held that that
To 137, sorry, I'm sorry, 123 to 137. Entire,
in 123 to 137
yes, sir.
had held that the framers of the Constitution did not mean that by the phrase inverted comma efficiency in administration in Article 335 can be construed on the basis of a stereotypical assumption that roster point promotees drawn from the scheduled caste and scheduled tribes are not efficient or that efficiency is reduced by appointing them. In paragraph 137, the racial, what racial, where is it?
136 it is there.
In paragraph 136.
It will bring about diversity and
No,
plurality.
that racial word.
Yes,
This one,
but
what
it is there in not anti-meritarian. Well, at 137, it refers to a Supreme Court, 127. It also said it is not anti-meritarian.
Of yours caught my attention that Supreme
Yes,
Court held that to go for
Well, I made two
efficient
submissions.
reserve, it will be racial.
Racial and anti-meritarian. Reservation is not
No, where
anti-meritarian.
is that word racial?
Well, it talks about the prejudice, at 125.
So you take your time, you find it out.
Yes,
Give it some time, take it.
yes,
Maybe, racial will keep.
Yes, sir.
Because of the accordingly, it is the contention of Mr. D.K. Das, the Council for the Reserve Category candidates, that the Supreme Court, having done away with the requirement of collection of data regarding backwardness, and also having held that data requiring inefficiency in administration is the collection of data regarding inefficiency in administration would cannot be on a stereotypical assumption that reserve category candidates are otherwise inefficient in administration. What further remains is the collection of data, quantifiable, the collection of quantifiable data in respect of adequacy or inadequacy of representation of the reserve category candidates in category candidates. But again, as had been again, the collection of quantifiable data in respect of adequacy or inadequacy of representation had also been circumscribed by the Supreme Court in General Singh Supra No, I have yet to differentiate the. So I'll deliver the using it. Dayanand Singh Supra reported in Kisor to Divan, SCC so and so. And therefore, such collection of data would now have to be understood as per this circumscribed requirement as provided by the Supreme Court. As the circumscribed requirement is to collect data cadre-wise and service-wise, therefore, it would be more prudent if instead of taking an exercise to obtain the quantifiable data in a comprehensive manner applicable for the whole of the state in respect of all such cadres and services that are in place. The same purpose can be achieved if the DPC, while considering any respective promotions, any promotions to the respective cadres, before proceeding with the promotion, obtains the data regarding adequacy or inadequacy of representation of the reserved category candidates in respect of such purported promoted cadre for which the promotion process would be undertaken. With regard to the contention raised by Mr. K. Chaudhary, Senate Counsel for the appellant Ivy Dasgupta and the other appellants in WA 162, that the provision for consequential seniority having been provided by the Constitution 85th Amendment, which itself is an enabling provision. Sentence that
With regard to the contention raised by Mr. K. Chaudhary, evidence showing that the provision for consequential seniority having been provided by the Constitutional 85th Amendment, which
is an enabling provision, comma, it is always the discretion of the state authorities who provides for such consequential seniority to also withdraw the provision of the consequential seniority as per withdraw the seniority as per Nataka. Withdraw the seniority. Next paragraph. Enabling provision in a statute is understood to be a provision which does not provide for any specific provision, but the statutory provision itself enables the executive to provide for such provision if otherwise advised or justified under the law. Meaning thereby that it is a discretion of the executive authority to either provide for or not to provide for. The only compelling circumstance that remains would be that once the provision, once in exercise of the enabling provision, a particular provision is provided for, till such provision remains in place, it would be binding on all as regards the existence and implementation of such provision. But at the same time, in the same manner in which a discretion was vested in the executive authorities to provide for such provision, if so advised and justified under the law, equally, it would also be open for the state authorities to withdraw such provision as per their own discretion, again subject to, if justified, in the circumstance in the law. From such point of view, from such point of view, we are in agreement with Mr. K. Chaudhary, learned senior counsel, that the OM dated 29/12/2014 could have also withdrawn the benefit of consequential seniority meted to the reserved category candidate by the earlier by the earlier office memorandum dated 12/3/2002. But at the same time, merely because the enabling provision enables the state authority to withdraw such benefit. But what would further have to be examined is whether the office memorandum dated 29/12/2014 in fact withdraws the consequential benefit of consequential seniority meted by the office memorandum dated 12/3/2002. To substantiate the contention that the office memorandum dated 29/12/2014 had in fact withdrawn the consequential seniority earlier given by the office memorandum 12/3/2022, Mr. K. Chaudhary, learned senior counsel, relied upon the clauses 11.11 and 14 of the office memorandum dated 29/12/2014. The provisions of clauses 11.11 and 14 have been therefore extracted in paragraph so and so herein above. A reading of clause 11 of the OM dated 1.11 of the OM dated 29/12/2014 makes it reasonable that it provides that the rosters are in aid to determine the entitlement of different categories with regard to the quota reserved for them. But they are not intended to determine the seniority. In other words, we are required to interpret the word one inverted comma they appearing in clause 1.11 as to what is meant by the expression they. The expression they refers to the earlier sentence in clause 1.11, that is the rosters, that the rosters are an aid to determine the entitlement of different categories. In other words, the expression they refers to the roster. The first paragraph of the office manual dated 29/12/2014 provides that the office memorandum had been issued consequent upon the amendment to the Assam Scheduled Caste and to the Act of 1978 and the acceptance of the recommendations of the one-man commission constituted by the government of Assam. We have to take note of that the recommendations of the one-man commission referred in the OM dated 29/12/2014 had in the meantime had been held to be unacceptable as per the judgment of this court in equality forum. At this stage, we take note that in fact there are two judgments available, both in respect of petitions instituted by the Society Equality Forum. One such is the judgment dated so and so rendered in WPC so and so, which is reported in 2016 1 GLT 710. And the other is the judgment and order dated is from an impugn order. What's the judgment impugn order? Single judgment order.
6/6/2022.
6/6/2022 in WPC 5005 2000
5005 of 2016.
2016 and 5028 2016. For clarity and convenience, we refer the judgment rendered in Equality Forum and Equality Forum Supra reported in 2016 1 GLT 71 to be Equality Forum Roman 1. And the judgment rendered and the judgment dated so and so is 660 in WBC 50016 and 500 to be Equality Forum Roman 2. What did you do?
First paragraph of the office manual of this 29 to 20.
No, no, I get it.
Provides that when the-
So,
when has
in other words, the purport of the office manual dated 29/12/2014 has to be understood that it was consequent upon the amendment to the Act of 1978. As already noted by the as already noted by the Assam Act X1X in Roman 19 of 2012, the Act of 1978 had been amended by which Section 5A thereof had been introduced. It had also been taken note of herein above that Section 5A of the Act of 1978 provides for post-based roster for implementing reservation in promotion. As the OM dated 29/12/2014 had been issued consequent upon the amendment by which Section 5A of the Act of 1978 had been introduced, comma. The word roster in clause 1.1 and the further provision that the roster do not intend to determine seniority would have to be understood in the context of Section 5A. All that Section 5A of the Act of 1978 provides is that earlier the reservation in promotion was given effect by following the procedure of vacancies. But upon introduction of Section 5A, the same would be done by following the roster points in the roster scale. If a reservation in promotion is given effect or implemented based upon the roster point in the roster scale, there is always a possibility that the reserved category candidate may be promoted against the post, which may be a little higher up in the roster scale, as the same roster point post may have fallen vacant. In that circumstance, the provision of clause 1.11 would have to be understood that the seniority referred therein related to the roster would mean that if a reserved category candidate is promoted against a roster post, which would be a little higher in the roster scale than the other promotees, merely by virtue of such of being placed higher in the roster scale, will not entail any seniority compared to the others who were also promoted in the same process and are placed perhaps a little lower in the roster scale. In other words, placement of a reserved category candidate in a given roster, irrespective of the position, would not determine its seniority, but the seniority would be determined otherwise under the law, depending on the manner and circumstance in which the promotion was given effect. It being the meaning of the word seniority, the provision of the seniority, it may provision of determination of seniority provided in clause 1.1. It cannot be understood that clause 1.11 of the OM dated 29/12/2014 relates to any consequential seniority of a reserved category candidate. The meaning of clause 1.1 having been attributed in the manner indicated above, now when we read the provisions of clause 14 of the Office Memo dated 29/12/2014, it is noticed that the said clause provides that all existing orders on the subject are deemed to have been amended to the extent herein above. The expression are deemed to have been amended to the extent herein would mean that it also includes the extent as provided in clause 1.11, meaning thereby that the aspect of determination of seniority provided therein is not related to any consequential seniority, but it relates to a prohibition that by following the roster point system, if a reserved category candidate is promoted in a post which is otherwise a little higher in the roster scale, that being positioned in the higher in the roster scale will not determine the seniority of that person corresponding to the roster scale. Accordingly, a conjoint reading of clause 1.1 and clause 14 of the Office Memo dated 29/12/2014 would have to be concluded that the provision thereof had not withdrawn the consequential seniority that was otherwise meted by the OM dated 12/3/2002. With regard to the contention of Mr. M.K. Chaudhary, learned senior counsel in WA 39, 239, they cover about 39 for years. Eta 46, eta 239, eta 1. Honor, right? But it should be non-credible. People.
Got to the conclusion of this linkage will be done on subject.
We take note that para 47 of the judgment dated so and so inequality forum 1 supra. There is an express prohibition by a judicial pronouncement that till such quantifiable data on backwardness, inadequacy of representation, and inefficiency in administration is collected, no reservation in promotion to the in favor the no promotion reservation in promotion in favor of the reserved category candidates can be further carried forward. But paragraph 74 of the judgment dated so and so inequality forum 1 supra provides for collection of data of quantifiable data in respect of backwardness of the reserved category candidates as well as inadequacy of their representation, which again would have to be determined cadre-wise and service-wise in the respective departments. And further, upon such data being obtained, there would be a requirement of a harmonization with the efficiency in administration as provided under Article 335 of the Constitution.
Race part I got. Race part I got.
Sorry.
Racial part I got.
Ah,
please.
ah.
It's in paragraph 116.
Paragraph 64, judgment dated so equal to forum 1 supra provides for collection of quantifiable
74, not 74. But the requirement of the provisions in the judgment dated so and so in equality forum 1 supra would again have to be read in the context of the submissions of Mr. Dikedas that in paragraph paragraph 36, General Singh 1. Yes, paragraph 36 of General Singh 1. And there is a presumption in law in favor of backwardness of the reserved category candidates. And In view of such presumption in law, there is no further requirement of obtaining any quantifiable data to substantiate the backwardness. So, Constitution bench judgment.
Yes, it's a constitution by 5 judges.
The said provision being rendered by a constitution bench judgment of the Honorable Supreme Court, comma, when read together with the provisions of the judgment in Equality Forum 1 Supra, it has to be understood that there would be no further requirement under the law for any collection of quantifiable data to substantiate the backwardness of the reserved category candidates.
For promotion.
Further, we also have to take note that in paragraph 47 of the judgment of the Honorable Supreme Court in General Singh two Supra of the General Singh Supra in reported in reported in civil appeal number 629 from 2022. Paragraph 47, it had been provided that the adequacy or inadequacy of representation of a backward the reserve of a reserved category candidate would have to be determined cadre-wise, service-wise, and in the given relevant department. Said provision it is noticed is also consistent with the provision in paragraph 74 of the judgment dated so and so in Equality Forum 1 Supra, that the collection of data regarding inadequacy or adequacy of representation would have to be determined cadre-wise, service-wise, and department-wise. Your standing disturbs my attention. If necessary, you tell, but right, sir. If the determination of the quantifiable data in respect of adequacy or inadequacy of representation of the reserved category candidates in a given cadre of a service in a particular department of the government, comma, we are in agreement with the contention raised by Mr. D.K. Das that it would be more prudent and appropriate to undertake such exercise through the departmental promotion committee itself before embarking upon a promotion process for a given for a given cadre. The same would be prudent in as much as the department will have all the data, the DPC will have all the data before it as to the cadre strength of the promoted cadre where the promotion is to be considered. And out of the total cadre strength, how many posts in the cadre are to be earmarked for the reserved category candidates? And out of the earmarked reserved category posts, how many posts are being occupied by the reserved category candidates? In other words, if the number of if the reserved category candidates are occupying all the posts earmarked for the reserved category candidates in the given cadre, it can be easily understood that in that given cadre, there is an adequacy of the representation of the reserved category candidates. And in the event the number of persons, the number of reserved category candidates occupying in the cadre is less than the number of posts earmarked for the reserved category candidate, it has to be understood that there is an inadequacy of representation in that given cadre. If the determination would be in the above manner, we are firmly of the view that it would be more appropriate and apposite for the DPC to make such a determination. But such determination would have to be made before initiating the actual promotion process. As regards the third requirement of obtaining quantifiable data, that it should also harmonize with the inefficiency in administration. We take note of the provisions of the Honorable Supreme Court in BK Povitra and others versus Union of the Supra reported in 2019, 16 SCC 212. Wherein in paragraph 127, it had been provided that 26, it had provided that efficiency in administration referred to Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promotees drawn from the scheduled caste and scheduled tribes are not efficient, or that efficiency is reduced by appointing them. And secondly, the provisions in paragraph 160 of the same judgments, wherein 160 wherein by referring to the Constituent Assembly debates in respect of the position expressed by Muhammad Ismail Khan. And then 16 colon. No citizen shall be discriminated on account of religion or race, and meaning thereby that an interpretation is sought to be given that if across the board the reserved category candidates are construed to be inefficient or contributing to the inefficiency in the administration without specific factual determination, it would be a discrimination on account of race, which would be impermissible under Article 15 of the Constitution of India. As a determination on inefficiency, a determination of the quantified data on the inefficiency in administration across the board in respect of reserved category candidates would amount to a discrimination on account of race, which is prohibited under Article 15 of the Constitution of India. We also have to hold that the requirement of obtaining quantifiable data on the effect of inefficiency in administration because of the reservation in promotion meted to the reserved category candidate. Thank you. Positive or negative.
the determination of.
No, sentence to put up. No, last one. Yes, will you cover again? No, will you cover again? You have to read the sentence, whether it is in positive or it is in negative. Negative is they say, why last one? Yes, will you cover? Positive is it say, no, will you cover? So you have to read the whole sentence.
As the determination of the quantifiable data will have to efficiency in administration across the board in respect of reserve category candidate with amount of the discrimination on account of race, which is prohibited under Article 50 of the Constitution of India. We also have to hold that the requirement of obtaining quantifiable data with the effect of inefficiency in administration because of the reserve, because of the
Promotion method to the reserve, reservation promotion method to the reserve candidate would also be a violation of Article 15 of the Constitution and hence impermissible. As the three contentions raised by Mr. M.K. Chaudhary, Learned Senior Counsel are answered as indicated above, meaning thereby that as per the judgment of the Supreme Court rendered in paragraph 36 in General Singh 1 Supra, there is no requirement of obtaining quantifiable data as required backwardness. And as per the judgment rendered in by the Supreme Court in paragraph 116 and 126 in B.K. Pavitra 2 Supra, quantifiable data on inefficiency in administration across the board in respect of reserved category candidates cannot be obtained, comma. And further, as the quantifiable data in respect of inadequacy or inadequacy of the representation of the reserved category candidates can also be done at the level of the Departmental Promotion Committee in respect of the cadre for which the promotion process had been initiated. We are of the view that the prohibition imposed by paragraph 37 of the judgment in Equality Forum 1 Supra would have to be understood in the manner indicated. In other words, as there would not be any requirement to obtain quantifiable data for backwardness and inefficiency in administration, and the data regarding adequacy or inadequacy of representation can be done at the level of the Departmental Promotion Committee, comma. The prohibition imposed by paragraph 47 in Equality Forum 1 Supra would now no longer hold good, subject to the condition that the Departmental Promotion Committee, before embarking upon each and every promotion process, undertakes an exercise to determine the adequacy or inadequacy of representation of the reserved category candidate in that particular given cadre where promotion is sought to be made. Anything over? Anything more?
Yes, at least our party.
I think other. Now, as regards the interpretation of clause 4 of the office memorandum dated 3/4/2016. 3/8/2016. We again quote the said provision, which is as below. A reading of the clause 4 makes it discernible that if an occasion arises during the promotion process in which the stipulated percentage in respect of reserved category is met, but in the gradation list stroke seniority list, there are candidates of reserved category candidate who on merit is also entitled to a promotion.
her case to be considered for promotion on merit only if such candidate has not gained seniority by way of accelerated promotion would mean that if the reserved category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserved category candidate, he would be entitled to the benefit of consequential benefit seniority as provided in the OM as provided in the office memorandum date 12/3/2002. But on the other hand, if the post earmarked for the reserved category candidate are already exhausted by being occupied by the reserved category candidates, but in the gradation list, there remains some further reserved category candidates, they can compete for promotion against the unreserved post. But in such event, their benefit that they had accrued under the consequential seniority will not be available. And but if on the basis of their seniority otherwise, that is without taking note of the consequential seniority, they are within the zone of consideration, such candidates can be considered for the promotion. Upon the issues being raised in the present appeal having been decided in the manner indicated above, it is provided that the decisions rendered in the present judgment in writ appeals Tinta would prevail over all such provisions of the learned single judge in the judgment on dated demand in 5005 and 5026. But in respect of any other provision which may not be contrary or inconsistent with the provisions of this judgment, the same may prevail. With further clarification that if any such provision of the order of the learned single judge is in conflict of or contradictory to the any of the provisions in the judgment, such provision shall not be given.
This part may not be given.
Clarify.
That will lead to, because the TPC is very, we have.
TPC, we are very clear. You just do that.
Yes.
This is an express positive provision. No DBC can give a different interpretation. If they give final contempt, we'll deal with it. They cannot.
Only, Lordship may add that in terms of Supreme Court's decisions prevailing, that will be better.
Which one?
Means any decisions by the DPC or will be in conformity.
That is always there.
So the problem with the government is that they don't follow the Supreme Court.
That is always understood.
Obliged.
Yes. Now, what to do with the writ petitions? Tell us.
The writ petitions,
They are writing about almost 20
Yes.
writ petitions.
Yes.
What do we do with them?
to my understanding, a lot of these writ petitions, the issues raised therein, the issues that your lordship had dealt out and dictated today, your lordship, would cater to the factual circumstances. Those are
See,
very
there are
factual.
two options available before us. We pass one common order in all the writ petitions that the issues raised herein, challenges made, shall be reconsidered by the state authorities in terms of the judgment rendered in the writ appeal. Wherever they are entitled, they will be given. Where they are not entitled, they will not be given. This is one way of dealing with it.
Yes,
One stroke.
Yes.
once, yes.
Otherwise, petition wise, facts wise, one individual decisions. If you want that, we are sending it back to the single judge.
No,
We can't decide a writ petition.
Lordship, in fact, what has happened, there's an order of the.
No, see.
Division
we-
bench.
We are listing the writ petitions again. Next
Yes.
week. You decide.
Yeah,
amongst
we'll
yourself,
make
take
our
your call.
submission. Yes, that will be better.
Two options are open. In one stroke, we'll say,
Yes.
send it back to the state authorities to determine the respective rights of the persons in terms of this judgment in the writ appeal.
or else we send it back to the single judge for individual determination.
My lord, so far as the judgment which your lordships have passed today will hold good in respect of the question raised by them in Bhagwan Pata's case, challenging the very policy of reservation promotion. That is
So
final.
now, some of the petitions are that reserved category candidates have come forward saying that reservation in promotion consequent seniority is not given to us.
Yes, about that, I'm making my submission.
Some unreserved category candidates are coming forward that it is wrongly given. So these are the only two
Contentious,
contention.
contentious issue.
My lord,
Those can be decided by the government.
may I clarify just? There were two issues. One is reservation in promotion, and second is if there is a reservation in promotion, what about the determination of seniority, whether it is consequent seniority or catch-up theory?
We
Lordship,
have already just our conclusion that 2014 did not take away the consequential seniority and it holds good, is good enough. That means consequential seniority is there till such time the state by a conscious decision withdraws it. And we have also provided, interpreted what is an enabling provision. Today, before we reach home, we can also withdraw it.
no matter what.
If you want, you can do that.
This is what I'm saying. Now, after that, my lord, the government has taken a fresh decision about consequent seniority.
Then that will prevail. We are not touching that decision at all.
18/1/2023.
It is.
That is the change I have made.
They will be decided, but then
It is stated that in the meantime by an OM dated
18/1/2023.
18/1/2023, the provision
Consequential,
consequential seniority had been withdrawn by the
no,
government.
has been provided.
Consequentiality
I'm
provided.
sorry,
Withdrawn.
Catch up here.
Again, same.
I'm sorry, catch up.
Had been withdrawn and the catch-up principle had been reintroduced.
Mine.
Had been reintroduced.
Yes,
We are not observing anything on
Yes.
merit on the state office memorandum. And as we have been told that the state office memorandum is under
Under
challenge
change
in
in some of the
a separate
petitions.
petition, which shall be determined on its own merit.
yes,
Okay.
that is all.
And the consequences of such office memorandum shall also be subject to what is provided in such proceedings.
Yes.
Those
yes.
proceedings. If there is a stay, there is.
There is no
stay,
stay,
there
madam.
there is
There is no stay anywhere.
that you follow.
My learned friend is there.
Okay.
In no case there is.
So now,
Yes,
single bench or can we send it back in one stop
here I-
or we determine?
my lord,
individually?
my lord, lordship possibly will send it back to the single bench.
Here I'll oppose
It's a
because
fresh
there is an
definition.
order of the chief justice
Not
bringing it to the, from the single bench to the division bench on the ground. that-
rest of the items of data command liquid video list again on.
Yes. that will
Yes.
be good.
You in the meantime,
Yes,
you take your call.
No. normally it has to go to the single bench manner.
Well, from single bench, the chief justice has brought it on our side. So it will again,
Nah,
why
no,
will we oppose it? Why will it be sent? The chief
No, no,
justice
but
has brought it
what
on
we
my
have-
submission.
But we have already decided the main issue.
No, not this matter, the
Yes,
OM,
yes.
the OM, subsequent OM.
Oh, there are also
Yes,
under
the
challenge.
honorable chief justice has passed.
That we have to decide. separately.
Yes. He wanted that he should hear it. The chief
OMO
justice-
2023 will have to decide separately.
Yes.
It's
Separate,
nothing connected
separate.
with it.
Lordship will not say that. Obliged.
Thank you.
Judgment will take some time to correct. It's quite a long one.